Hey everybody. Good morning.
Hey y'all,
I was like, "Go on, Donna." We're
Donna
just
here.
waiting. Hey Beach Bum, what's up? How you doing? How you doing? And Lamisa, how you guys?
Oh shoot, I've got it in the back. Where
Huh? You got it in the back.
you know what I'm
What's up?
saying? I have an echo. I had the other window talking too.
Oh. And do they normally just flip?
Yes, but this is on a delay, and you know how come I know that? Because I
Mm-mm. How you
accidentally
know?
set it at 1.5, so I don't know how much delay it is. But if it was live, it wouldn't have speeded up those people walking around.
That's
So
true. It would sit there and buffer once it catches up. But did you press live too? Like at the bottom. Wait, where the frick is mine? I'm looking for there it is. You hit like look, I'm gonna show you. This, you hit this little button right here where it says live.
oh no, I think I was live. I was live.
Okay. All right. I was just
See,
wondering.
who
Let
is
me
this guy? He gave a statement yesterday. This guy did. This big guy here. Who
I
is
don't know.
he? He looks like a football player or a
I can
security
find
guy.
out. I can find out. Let's see.
Well, I mean, he's probably not important to the story. Maybe he is. I don't know.
I mean, did he testify?
No, I'm saying yesterday when he
Okay.
came in, he they did like you could see they were doing a
Documentary or something?
an interview with him, but it wasn't, the AP camera wasn't picking up the audio. You could just see him talking, but I heard him say something about conspiracy theories and this, that, and the other. And
They're trying to shame everybody for questioning things. You don't have to be a conspiracy theorist around here. You just have to simply raise questions, and then you're bullshit. Like you're mean. Don't question Dr. John's credentials. How dare you? That kind of thing. Like don't
yeah,
question.
well, exactly. I mean, and you hated to hear the lawyer yesterday trying to beat down the expert on DNA about that, and you're thinking, oh my God. But what he was getting to was not, maybe he was getting to her expertise, but that there's a measure of error and all that that really
Yeah.
I wasn't aware of
Hmm.
till he did all that.
Yeah, and I mean that's their job. And if it were me, having to defend myself, I would want, I mean, yes, chisel away at it, please,
I
especially if
think,
I'm innocent.
and Nate said he had never seen a hearing like this because there's so many people represented in there. There's like, okay, we got a lawyer for the media, a
Yeah,
lawyer for the defendant, a lawyer for
for
the
the
prosecutor,
families.
a lawyer. Can you imagine your
I
mama
can't
sending
imagine us
somebody up there?
exactly. Right, like, oh, and then them
And a dude,
crying, and
I
then
also noticed
that's
they
so
showed up
prejudicial.
in like military or Secret Service kind of uh, cars when they showed up in the
Yeah.
morning. They had twin cars. Erica got out of one, and the parents got out. I mean, they were exactly the same. I think they might have been Lincolns. I don't know what they
Now, I
were.
saw the parents already arrive.
This was not today. It was yesterday. But I'm just saying. Can you? I mean, it would have been something if the Secret Service had to come and pick y'all up. They said, "I'm coming to pick
I mean, the
you up,"
cops did.
and you were on a hit list,
Yeah. Well,
technically.
no, but I mean, the police officers, the investigators brought us. They'd pick us up and bring us.
Oh, okay. Well, good.
Yep. I mean, no FBI. Well, yeah, one time it was FBI, but it
Well,
was
good.
mainly, the big, tall guy. I can't think of his name right away. And the other one, Vince Kayakamanu. I don't ask me to spell it. I know,
Well, I'm
please.
just going to say maybe they're familiar with the LDS having dang people at the places like funerals and courthouses to do a mass shooting of the whole family. They're,
Right?
and
I mean, I don't know.
I'm going to open up my Dr. Pepper and try to calm myself.
Do you?
Well,
do you? Oh my gosh! I'm looking at this Baron Coleman. It's 3 hours and 54 minutes.
no,
You know.
we'll have to look at the
Well, I
transcript
mean,
and we'll have to
yeah.
get a short of his transcript and
Let me
go through it
see.
because he had a lot of
I'm
points.
gonna try and
but
pinpoint it right now. That way I can.
okay.
Is it the Andrew Colvett does TikTok to try to salvage something, anything? Then there's Operation Erica Kirk actually is nice in full effect. Then there's Erica Kirk's lawyer irritates judge and everyone else. Then Lance Twiggs video testimony can't identify Tyler 100% and has more major problems.
That
Then
was a good part too, because I mean
okay,
he was saying if it was
well
my
hold on,
lover,
I'm gonna pull them. Okay,
okay,
just real quick. As Lance Twiggs and Tyler Robinson texts have timeline and even bigger problems. Isn't that one
yes,
too?
yes, yeah, that
Um,
definitely is what we want right there. That's the
missing.
main thing.
Okay, missing fragments and wrong size fragment not matching purported what Tyler Robinson is a terrible shot based on targets. What did we learn? Reasonable doubt is over. Okay, all right. Let me pull this up.
Okay,
Ooh, ooh. All right. So for right now, everybody, Donna's gonna keep watch on whenever they transfer over to the court. So for now, she recommended we watch some Baron Coleman points that he made that she found to be important. So here we go. Baron Coleman. I'll put the link in the chat. This is from yesterday.
So getting to today's hearing, we had Lance Twiggs, but not in court because that would be transparent. That would have given the defense an opportunity to cross-examine him. So we in our claim to want to be transparent, we don't really want to be transparent. The state doesn't, surely. Instead, we want to carefully curate what you're allowed to see.
Yep.
But we got Lance Twiggs.
Hey, Alpha Film.
We
Hey,
got
Sparky.
Lance Twiggs.
Hey, Jennifer.
Let me close these two. And he says,
Hey, Faye. Angela.
he says right here, he did not get a text from Tyler Robinson all day until, now this may not be the loudest video I've ever played. It's as loud as I can make it. I can turn it up on this end a little bit, but I think that only goes to my ears.
Louder.
And I don't know if there's closed captioning yet. Oh yeah, there are. Here we go. So let me share this with you. We got Lance Twiggs talking about his communications with Charlie that day.
Get up on September 10th.
Man, they're taking forever today. Huh?
Probably like 12 to 1 p.m.
You didn't have to work that.
So Lance Twiggs conveniently slept through the event.
they're probably arguing about the same
Conveniently
thing.
slept through the event. Tyler Robinson got up at 4 a.m.,
Probably.
allegedly left the house. Lance Twiggs was just snoozing. Just snoozing.
That's what young
12 or
people
1
do.
p.m.
That day.
No.
And
Okay, he didn't have to work that day. That's awfully
did
convenient.
you hear from Tyler? Did he call or text you before then?
No, he sent that message in the group chat I mentioned, but he didn't message me directly at all that day.
Hey, Faye.
Okay. When did you first hear from him on September 10th?
It was at 11 o'clock with that like automated message.
So that's his testimony under oath, under penalty of perjury.
Allegedly.
He was advised, and I can go back and play it for you. He was advised that he had to be honest, that his deal.
I have to say that it's a use immunity, but if you roll back and think whenever Zalema had use immunity in Chad and Lori's trials, she had to go. I mean, this dude lives allegedly like right in the area of the courthouse, or at least within the state. So
It's
I
a
just don't-
tactic to keep people
Yeah.
to keep them from being able to question him. But they said he will have to testify in a real trial.
we better. They better make robot detectors.
Depended on him being honest.
Hey, Sacred Secret Society. What's up?
Well, that's weird. That's weird
It's so weird. All of it's weird.
because, well, actually, where are the
we're still
texts?
waiting for court to start.
Daisy. There
I
they are.
can't speed this up a little bit.
That's really weird because you didn't hear from Tyler all day until the 11 p.m. auto text. Well, let's take a look and see if that's accurate. There's the 11 p.m. auto text. Drop what you're doing. Look under my keyboard. What's that right above it? You see that right there? Wednesday, 4:33 p.m., Wednesday, 11 p.m. So his testimony under oath was, I did not hear from Tyler at all until 11 p.m. That's his testimony. Drop what you're doing. Look under my keyboard. But that's not true because he heard from him at 4:33 p.m. I love you, mwah, mwah. I love you, Morsies, mwah, mwah, mwah.
Oh my God.
Notice the drop what you're doing, look under my keyboard, and the
Drop
I love
what
you,
you're
mwah,
doing.
mwah
Sorry.
are from the same person. They're from Tyler Robinson. If you don't believe me, it says it right here, according to this screenshot, if this is at all accurate.
Right.
So we have him just bald-faced lying under oath. And don't tell me he didn't remember. Guys, this is an 11:02. This is prepared testimony. This is in a controlled environment. You don't think those text messages were in that room? You don't think the text messages were in that room?
Wow.
That Tyler Robinson sends a text message at 4:33 p.m. and Lance Twiggs even responds to it and then goes and testifies, no, I didn't hear from him until 11. Okay, so we're off to a bad start. That was only 6 minutes into the video. Already. But what was not asked? Think about the questions that weren't asked that might have been asked on cross. Is it at all unusual that he would leave the house at 4 a.m. and you wouldn't hear from him until 11 p.m. and you wouldn't reach out to him? You wouldn't worry about where he was? You wouldn't wonder if he's okay? This is supposedly your boyfriend?
Yeah.
22 years old? I mean, I've got teenagers. I know how they text. You can't ever see them. Their face is always looking down at their phone.
Right. Right.
You don't get a text from him for,
Hey, Amanda.
what's that, 8 plus 11, 19 hours?
Hey, Cheryl.
You don't know where he is because he didn't really tell you where he was going? And you don't wonder what's going on?
Exactly. That's what I would be worried about.
The interesting thing about the 4:33 p.m. text is if Lance Twiggs was there, that's about the exact time he would have gotten home. That's about the exact time he would have gotten home. It's very convenient that he slept through the event and did not hear from Tyler until about the time he would have gotten back to St. George. But did he actually know what time he left? Let's take a listen and see, can we even believe him on what time he left the house? Do we know Tyler left at 4?
So again, those messages covered from September 10th to the evening of September 11th. Now, September
Hey, love always.
11th, what time did you see Tyler on September 11th?
Yes.
When did you first see him on September 11th? So this is the day after the shooting.
Yeah, I saw him when I woke up. Like I said, he was up and around doing a lot of stuff around the house.
Saw him when he woke up the next day. Well, we've looked at these text messages a lot. I don't have to pull them all up and show you, but you remember how he was like supposedly at his mom's house and I'll see you in a bit. Do you have a reason to leave your house? I'm on my way back. You know, he stopped and got gas in Cedar City at like 7. And so we were trying to make a timeline in our head. But now he's saying he saw him when he woke up the next morning. Again, this would have been nice for cross-examination. This would have been a nice opportunity to, even if you're just clarifying, hey, we're trying to put a timeline together. Our client is on trial for his life. Can you clarify why the text messages seem to indicate you were at your mom's house celebrating your birthday, and now you're telling us you saw him when you woke up the morning after?
Very divergent.
Well, surely, though, Lance, being the fact that you live with this guy, you see him every single day. You see him, if the Turkey Tom video is to be believed, you see him in various states of dress, up close and personal.
I keep checking.
Tell us about these pictures that we have of Tyler Robinson climbing stairs. Tell us what you know about him.
Okay, before he came home, had you seen the press releases, any of the media on this?
I'd seen one
I don't see his
Instagram
mouth.
link a friend of mine had sent in our group chat,
Here it goes.
but I hadn't really looked into it at all.
And had you seen the images that were released of the suspect?
I see. The
I did the next day. I don't think I saw any on the 10th.
Do his lips move at all?
Okay. I'm going to stop here for a second.
Hey, John.
We are told that Tyler Robinson, who lived with this guy, was so outraged by Charlie Kirk's mere existence on this planet that he had to eradicate it.
Exactly, Beach.
But the guy he lived with, the guy he did it for, supposedly, is so oblivious to everything that's going on
Right? Y'all are funny.
that when he learns that Charlie Kirk had been taken down, doesn't care enough to follow up on it. It's the biggest news story in America.
It's the biggest.
Every
not
major news station
news
broke their
story, but-
coverage
Oh,
and joined in progress the on-the-ground reporting that was taking place in Utah.
that is true.
It was on ABC. No, I like every NBC, CBS, Fox.
I want to ask, because I didn't witness that news break in and witnessing Charlie allegedly get shot. And I mean, are any of you here? Did y'all witness that live? Or I don't know. I was very glad I didn't have to see that. I could kind of dart after that.
All the cable news channels, every social media feed, that's all anybody was talking about that day. Go back in your mind to September 10th in the afternoon. That is it. That's all anybody wanted to talk about. Now, I could believe that a guy like Lance Twiggs might not care. But if a guy like Lance Twiggs didn't care, would his boyfriend really care enough to do the deed? Like what? And if Lance Twiggs wouldn't care, would Tyler try to remove Lance Twiggs from the planet on his behalf? Because we'll show the text message in a minute. That's what he claims. I did it for you, my love.
Mm.
Well, he didn't care. He didn't even notice it happened. He saw an I might have seen
But
it
he
on
knows
Instagram as I was
everything.
scrolling and
Yeah,
moved on.
he knows everything though. That's a little weird.
If it is true, there's no stupider person on the planet right now who feels dumber than Tyler Robinson. Because Tyler Robinson supposedly did this for Lance Twiggs. And Lance could not have cared less.
I think
Could
that
not
theory fell
have cared
apart.
less. Now, do you believe that story?
Nope.
Do you believe that in your heart of heart? Lance Twiggs was the only guy on earth who did not care about the story that day. But he goes on.
I'm going to show you a couple of those images.
What happened?
Showing the pictures.
Okay, I'm on the FBI's website. You can see the URL there at the top. This is a press release about this event. And here on the screen, you see these, looks like there's 2 rows of 3 images.
Mm-hmm.
Do you recognize the person in these images?
I wouldn't say it with 100% certainty, just
That's called reasonable doubt. Pack up the case. We're going home. I wouldn't say it with 100% certainty. I'll let him finish in a second. I'm going to let him finish to put it in all context. But that statement right there is the definition of reasonable doubt. If your own live-in boyfriend doesn't recognize you with 100% certainty, then excuse me for not believing Brandon Tatum and Jack Posobiec and Andrew Colvette and Blake Neff and all the lackeys on the other side saying this is an open and shut case. Because the own boyfriend cannot put him in that stairwell beyond a reasonable doubt. And these are the best pictures we got. This is the best we have.
That's pretty.
There are no clearer images of Tyler Robinson or whoever's supposed to be Tyler Robinson. There are no clearer images of this human being on the campus of Utah Valley University that day than these 6 pictures.
That's
And the
wild.
live-in just said, well, I wouldn't say it with 100% certainty. Ladies and gentlemen, the defense rests.
Yep.
That's it. It's over. I mean, you can show me a towel that you found in a bush. You can show me a screwdriver that you found on a roof. Well, guess what? He's not accused of throwing a screwdriver 142 yards and hitting Charlie Kirk in the head or the neck. So I don't care about a screwdriver. He's not accused of strangling with a towel. So I don't care about a towel.
Just like Richard Allen. Nobody was shot.
But if your
worried about a gun.
live-in boyfriend cannot immediately 100% certainly recognize you when your face is on the camera, then you cannot expect a jury to do the same. You cannot expect a jury to do the same.
I'm just letting y'all know that we're still waiting on court. Look, this is what it's showing. Oh, not now, but I had it. It's live. So just letting you know. What did that just say? All right. Share this tab instead.
I'm going to back up a little bit and we'll do this again without my interruption.
Do you recognize the person in these images?
I wouldn't say it with 100% certainty just because of camera quality, but that looks like him in terms of the shoes he's wearing, the sunglasses. I don't think I'd specifically seen him wearing that hat, but he was usually wearing a hat, and then jeans. So,
which I want to just kind of put this here. I like to do this. This is alleged body cam footage of Tyler Robinson, May 31st, 2022, because of a car accident. And I mean, so this is him, allegedly.
One of those two lanes going this way. I think in the right. Yeah, in the right.
Is this his boyfriend? I don't look like it, but
There going left. And as I was coming through, he turned in and I T-boned into the side. Okay.
but just trying to get a feel for his clothing. See, look, oh shit, hold on. Whoa. I'm trying to look at his shoes. I wish that bar would move down. Phone in the front pocket, like the, the cutout or whatever. Kind of like when guys used to dip with their skull cans. I'm backing up. Anyways, just to get an idea. Still waiting on court. Go back to Barron Coleman. I put his link. It's right there at the top. I mean, at the bottom of the screen.
It's the dignity of every person
Hold
involved.
on, I didn't. What? Oh,
All right.
is it court? I'm so
My
confused.
understanding is the parties wish to address an issue before we get started. Is that correct?
We may.
Mr. Novak.
Can you make sure the volume's up?
Thank you, Your Honor, and good morning. I passed up to the court after providing copies of it to counsel for the state and counsel for the media, a single piece of paper. Does the court have that?
I do. Thank you, Mr. Novak.
Thank you, Your Honor. So every morning, this court has a colloquy with the camera operators about their ability to comply with this court's orders. And they acknowledge that they understand the order and that they can comply with it. And the court asks them if they have any problem with it, and they state to the court that they do not have a problem with it. We also spent many, many, many hours of court time addressing which exhibits will and will not be published through the electronic media. And this exhibit, the court ordered would not be published through the electronic media, and it was. And without belaboring the point, the court can imagine our concern that the media and the state who control this exhibit and
Can y'all hear it?
publication of this exhibit in the courtroom, as per the court's orders, failed to comply with this court's orders after all of the effort that we made and the court made to make sure that the court balanced everybody's rights.
Pull yours up,
including
Crash.
the rights that we're concerned about, which are Mr. Robinson's. No doubt the counsel for the media and counsel for the state will say that it was a very, very concerned about, which are Mr. Robinson's. No doubt the counsel for the media and counsel for the state will say that it was a very, very brief mistake, that it was corrected as soon as they realized the error, but it's done. It's out there, it's photographed. I'm informed secondhand that if I want to buy this image and maybe even have it framed and put behind museum quality glass, I can do so and put it up in my office. Obviously, I'm not going to do that. But my point is, it doesn't matter how long the court's order was violated. When we live in an electronic world, it's done and it's permanent. And we just wanted the record to be clear that we're concerned that the court's orders have been violated, and they've been violated with respect to an order that was specifically designed to protect Mr. Robinson's right to a fair trial. And I don't want to belabor the point any further. I'm also not going to refer to the exhibit with any more specificity because it's not necessary.
Is there a requested remedy or potential sanction that you feel is warranted given the actions which you have outlined this morning?
I think that we would like to think, when I say we, I mean Mr. Robinson's counsel, about that. We have, as the court knows, repeatedly asked this court, moved this court, not to have electronic broadcast of this proceeding, of any of the proceedings, and specifically this proceeding. The court denied those motions and overruled our objections to the specific EMC requests. So I think it's a little premature, but I can represent to the court that we will suggest a remedy in advance of the next hearing.
Well, Mr. Novak, I appreciate that, but I would ask that if it is something that is concerning, that it be addressed immediately. So I'm not going to wait until this. I recognize and appreciate what you have described, and this was on my mind a lot last night as well.
Okay.
I don't want to sit on this. So I ask you respectfully to confer with your counsel and come up with that, because I want to address it. I agree. It is concerning and it warrants examination and to be addressed immediately, especially as we have a little bit left of our preliminary hearing. So I want to give it the weight it is needed, and I don't disagree with you.
Then why don't we beg the court's indulgence? We don't need to empty the courtroom. We can go talk about what we think an appropriate measured sanction would be. And we can bring that suggestion back to the court in a few minutes.
All right. Well, before we do that, I want to turn to the state and to the media to address what you've addressed. And then obviously if there's a part two, then therefore.
And I appreciate the invitation. And I also appreciate the court's desire to address the consequences, if any, immediately.
Thank you, Mr.
I was not
Novak.
trying to delay it. I just think it's an issue which warrants some thought. The court has said it gave it some thought. We will have a suggestion very briefly.
Thank you. Turning to the state.
Thank you, Your Honor. I think at the outset, it's important to recognize that everyone's doing their best here. The court is, I know the clerks are, I think the media is, we certainly are, and the defense is. This issue came up in the context of an examination of a witness. One exhibit was published before the exhibit at issue was also brought onto the screen. I explained what we were going to do, and then the exhibit was brought onto the screen. I reviewed the video last night. The camera captured this for approximately 2 seconds. The camera operator, I think, acting in diligence and appropriateness, immediately panned as soon as she realized that there was a new exhibit on the screen. The court took it down, and as soon as they realized that an exhibit was on the screen, I immediately instructed my paralegal to take it down, and it was. Defense, I think everyone involved here made quick and appropriate efforts as soon as they realized a mistake had been made to remedy and mitigate that issue. As I explained what I was what we were going to do, defense counsel did not object as that happened. And the reason I bring that up is because of the requirement for timely objections. Moreover, I do want to say this exhibit was read into the record. It was allowed to be read into the record earlier. It is also in an earlier pleading, which is the information. This portion of that exhibit, I understand, is in the information. And it is largely cumulative of Exhibit 16 and 16.1, which were previously admitted into evidence and published to the media. Finally, we are going to be dealing with a lot of publicity when it comes to media coverage. And I think that's really where the remedy is going to be addressed. I understand there may be a remedy that can be fashioned today to prevent this kind of thing going forward or going on in the future in this hearing. But I think ultimately that's where this will be addressed. Any other questions from me, Your Honor?
Well, not at this time. I will afford you the opportunity, obviously, to respond when the defense comes back. I want to weigh this and taking in consideration, and I find your representations to be accurate as to what occurred. I believe that I noticed it and asked for it to be taken down because I have a live stream on my screen for that very purpose. And the sequence, I believe I made note, and if I'm wrong, please correct me. It's been a long 4 past days, but that's the only addition that I find to the representation. And certainly, Mr. Novak, feel free to correct it if you believe the sequence was any different. I just want to make sure a clear record is being made of what happened in order for whatever happens next to be appropriate and proportional to the actions that occurred.
No, and that's consistent with my memory. And I also reviewed the video, the live stream as well in preparation for this issue today. So that's exactly what I think happened. From my perspective, examining the witness, I did not have a view of what was being published to the public and the media. And so I think the court immediately, as soon as it recognized that, brought that to everyone's attention.
Thank you, Mr. McBride. To the media.
Good morning, Your Honor.
Good morning.
Appreciate the opportunity to be here to speak on behalf of the media. I think our understanding of what happened is consistent with what both the defense and the state have said here. So I don't want to belabor that point, but here's how I understand them. There's 2 exhibits at issue. Those exhibits were used yesterday in part because the juxtaposition of those 2 exhibits might have provided some sort of benefit to the court. The first of those exhibits was asked to be published through all 3 of the court's phases. The court said it will be admitted into evidence, be shown in the courtroom, will not be shown on the cameras. That happened about 3 hours into the hearing. That all went smoothly and well. That operated exactly as it is intended to. That requires the participation of everyone, the court, the defense, the state, media, camera operator, all to do that well. Later in the day, when in the video I reviewed, this was about 5 hours into the runtime yesterday. The second exhibit that was going to be compared side by side was introduced. That also went through that 3-step process. In that case, the court said that could be admitted into evidence, shown to the court, and then also shown on the cameras. So it was put on the courtroom cameras. At that point, there was what I think is a useful practice by the camera operator to wait a beat, because sometimes mistakes do happen, right? In that case, though, that was authorized. So the camera then panned to the screen, which is set up specifically for the camera operator to be able to capture that. Examination on that exhibit began. Then, because the examination seemed to call for that juxtaposition, without much warning for anyone involved, the previous exhibit that was intended to be juxtaposed was placed on the screen. From, I think, a observer's view who didn't know where the testimony was going without warning. The camera operator, I think quite astutely, within seconds, recognized this is a different exhibit, and recalling the court's prior order, recognized I should pan off, and did within seconds. I think at the time that was happening, the court also caught that and said, let's not do that. Now, and that was the end of it. I think the 2 seconds is about right. I don't want to minimize that. I understand the point that Mr. Novak is making. We are operating in some ways on high wire, and we are trying to place as many nets as we can, and all the parties are working together to try to do that. But in the age in which we live, one of the challenges is that sometimes when something like that is placed on a live screen, someone can screenshot it, and like Mr. Novak said, if they want to put that for sale on the internet, then they can. That's why working together to ensure that even small mistakes like that don't happen is critical. And the media has the media coalition that are given the opportunity and the benefit of being able to be here to run cameras and to take photographs have complete buy-in on that point. There are, of course, people out there watching a live stream that are not part of our coalition that we can't control. And that's why it's so important that we get these pieces right. I do want, without going too far into the evidence, to note not only that several lines of this exhibit are available publicly in the information, but that the full text, every word of that exhibit is contained in a search warrant, in this case, that was initially filed on September 17th. This is in the 4th District, but in a different court, was held for 6 months, as search warrants often are. But then on March 17th, March 16th, March 17th, was released in full. On page 7 of that search warrant is the full text of this exhibit. I don't want to suggest that anybody gets the right to say, well, I think it's public. The court has said don't show it in the screen. But since I think it is, we'll just come back later on and tell the court it's not a big deal because it's already public. That's not how it works. If we say we think it's in the public, the court says, I understand that, but I'm going to make an order. That order should be adhered to. But I do, for the purposes of prejudice, for potential remedy, for the court's concern and the court's sleepless nights, I do want the court to know that as well. And members of our coalition have pointed out to me as we've talked about this, while we take this very seriously, it is true in this case that the full text of that, not the image of the exhibit itself, but the full text is already in the public sphere, has been reported on, and is out there. I only want to reinforce, to close, the recognition that the media, our coalition, I, as an attorney for that coalition, have an obligation to make sure that mistakes don't get made. And in this case, even though I believe that the camera operator didn't act in violation of the court's decorum order, didn't do something that was forbidden by that there was an order that said, don't publish this exhibit. And because it flashed on the screen when the camera operator was filming that screen, that did happen. The media is fully bought in. I, as one of the attorneys and the other attorneys for the media coalition, are fully bought in on a goal to make sure that this kind of thing doesn't happen. Of course, I understand Mr. Novak and the defense's need to make a record and make an objection. And I also recognize and appreciate and understand the court's role in trying to make sure it imposes whatever sort of direction, caution, sanction, response that it believes is needed to make sure that its orders are recognized and adhered to. And I want the court to know that we will understand that and will comply with whatever it is that the court orders.
Thank you. Anything further before we break? Mr. Novak?
We don't need a break.
Okay. Well,
The court wants a break.
I want to review this. I'm sure there is a stream out there. I want to look at it again in order to appreciate the full effect and exposure. I remember it, but given the nature of this and trying to weigh the constitutional rights of all parties, I want to be thorough and look at it exactly. So as we move forward, as I evaluate what's being requested by the parties, that I am at the level of knowledge, and because for what it is, it was on screen. I want to look at it, how long, what exactly was on screen, and in order to be at the point of saying, okay, I fully understand. I mean, I was here, I saw it, I noticed it on the screen, but again, I want to take that extra 2 minutes to review that.
I'm not suggesting that we rush through this at all. I just wanted the court to understand that our request for the remedy and the sanction, we are prepared to share that with the court, but we can certainly wait until the court has had an opportunity to review whatever the court thinks it needs to review. The permanence of this violation of the court order is a different issue from how long it took to correct the violation. It's a permanent consequence. In other words, that image is out there forever and ever in violation of the court's order, no matter what actions the court, the state, and the media took to remedy it, because that's the technological world we live in. So that's my response, if I may, to the arguments. But we can hold our suggestion until the court's ready for it.
All right. If the parties feel it'd be helpful to confer while the court is reviewing it, you may, just so that if you choose to, I encourage it. If you don't, I respect that. A court's going to take about 5 minutes. Again, I just want to review it, to be brought up to full speed and just to have it freshly in my mind.
I'm going to make one more point, if I may, and that is, this is not the first time that this has happened. We had earlier proceedings in this case where the cameras depicted images inside the courtroom that the court had prohibited, and the court imposed certain consequences on the media as a result of that. And so that's just something to keep in mind, in my opinion, if I may. Thank you.
All right, before the court takes a 5-minute recess and to review this, does any party need the benefit of the record based off the dialogue between me and Mr. Novak? All right, not seeing any party respond. The court's in recess. We'll come back at 9:45. Court is in a brief recess.
All ready. All damn ready. Right? All right. So an hour. It's 9. It'll be back at 9:40. Wait, 10:45. Right? What the fuck did he just say? Hold on. Let me back it up.
Media coalition that are
Oh, no.
The court has had an opportunity to review whatever the court thinks. The permanence of
Come on.
this
Get to the point.
actions the court, but we can hold
If the parties feel it'd be, if you choose to, I encourage you it to be brought up to full speed and just to have it freshly.
depicted images of,
Just a 5-minute recess and
Oh,
if I may, thank you. The court imposed certain.
if-
damn it.
to have it freshly in my mind.
We're doing
May I
it
make
live.
One more point, if I may, and that is, this is not the
Oh, my
first time
God, dude.
that this has happened. We have
Oh, my
earlier
God, man.
imposed certain, if I may, thank you.
All right, before the court takes a 5-minute recess and to review this, does any
5 minutes? Hold on. What the? I didn't mean to hit that.
any party need the benefit of the record based off the
5 minutes.
dialogue between me and Mr. Novak? All right, not seeing any party respond. The court's in recess. We'll come back at 9:45. Court is in a brief recess.
Okay, so 4 minutes from now. I was thinking like a damn hour. I'm glad I looked. Yeah, 5 minutes. Got it now. Thanks, y'all. Wish I could see those comments while I'm digging. Yeah. Thank y'all are very, very alert. Good job. All right, let me put this live and mute it. Anyways, what do y'all think? It reminds me of whenever Judge Boyce would always take it under review.
Yeah.
I always pictured him going call his buddies. Being like, what do I do? Calling the church. What do I do? In my mind.
Well, it seems like every time they have all of them are just like, I'm the boss here and I'm going to tell you what the law says. And it was like back and forth and back and forth and back and forth.
Yeah, and they're like, but.
Felt like
Everybody's gotta
Groundhog's
add
Day.
Yeah. Much like that. Do you guys like the chat being on the screen or no? I'm just wondering. An echo? Uh-oh. Donna, we're going to have to get your sound. We'll have to do a sound check session or something. Me and you. Try and get you. Because, it used to be on point. And then, anyways, I'm not sitting there bitching or nothing. I'm just making an observation. I think.
Sound check might be a good idea.
Yeah, just to kind of work out the quirks. I know it sucks because I have this whole voiceover that I did that I had the gain turned up too high. Oh my God, I won't publish it. That sounds like crap. Oh man. Oh, just me? Just I have an echo?
Is your gain turned up again?
No, echo, they said.
I don't hear an echo.
Is it? Do you have an extra window open or something? Maybe?
Me?
And it's here in the background?
Me?
I don't know. Yeah. What? Do you know
Of
what I mean?
course.
Oh. Yeah, let me take that off.
No, I'm making sure. My mother in the kitchen. Y'all may hear my mother banging around in the kitchen.
Yeah, I heard that. I kind of hear it too. Weird.
I'm
Do y'all
gonna go
hear it
shut
when
the
Donna
door.
talks? Do y'all hear it when Donna talks? Will you talk?
Okay, I will talk now. Do y'all hear that noise when I'm talking? My mother's banging dishes in there. I'm fixing to go shut the door.
I don't hear an echo when you talk. I just hear it after I talk. Weird. Yeah, I'm gonna go out and come back in. Good idea.
Okay, okay. Here I be, y'all. It's crazy, isn't it? I need to make sure that I don't lose the where we're gonna be. Let's see. That's us. We don't want to see that. Oh, me. There she is. There she is. She's still got to load her stuff up to
Sorry.
go in.
I was going to load it up first, but I didn't want to leave you hanging.
That's
Let's
okay.
see. Do y'all still hear an echo? Do you? Well, I don't know what else it could be. I really don't. It is a soft echo.
Well, make sure your gain is not. I'm going to do mine too. Let's check our gain.
You need to click the option where it says in StreamYard where it asks you to, for audio, go to echo cancellation. Oh, wait, you use headphones. But let's try it.
I did. I just did it. Does that help?
I mean, can you turn the gain down on your mic?
It's like I'll have to read on there what the gain is. I think I got
I can
it.
hear you better. I won the
About
tech
now?
board. Let me fix it. Okay, talk without, without.
Hello.
Yeah, that sounds much better. What do y'all think? Talk some more. You gotta talk.
Hey, y'all. Testing 1, 2, 3. Testing 1, 2, 3. I
Bing
hear
bong.
some kind of bing bong.
Do you hear bing bong or do you hear better?
Oh, it's fine.
You sound so much. It took out all the background noise. We don't hear your fan. That's awesome. It is an echo? So it's me that's echoing the voice, right? But only when Donna is not muted. I don't know, Michelle. Is this some weird shit? Whoa. How about I can see his dandruff? Holy shit.
That's a little.
Saw that?
That's a little poor little man. Yuck.
Ugh, right? I'm so sorry, y'all. Ugh. I can see his hair follicles. Spit and spooge. Spit and spooge. What the fuck?
Damn it.
Can you get out of his fucking hair? There's dandruff right here somewhere. I saw it earlier.
Yeah. Oh my God. There's probably stuff crawling on them.
Oh, remember the Corey Richards? There was that girl that had that. I don't know. Look, she was eating her hair, literally things out of her hair. Yeah.
Why are they? That is just too close up.
He wasn't paying attention. Sound is good now. Crushing Donna. Okay. People hearing it might be just coming in a bit behind. Oh, high five, high five, high five. It
Yay.
is such a close up. Who? Me? No. I'm just picking. TMI camera dude. Yes. Well, I know that's bad. That was crazy. That was crazy. Good. Thank y'all. That was not painful either. So that's good. But she's not muted. So I can't
No,
tell
I'm
when you're
here.
on now, so that
I'm trying not to be too mouthy.
I don't have the tattletale now. I don't hear the That's good.
Well, that's good. That's good.
Yeah.
Very
Y'all.
good.
So
His hair's, yeah.
I'm sorry. What I'm working
just-
on right now, Lavisa says we sound better than Nadine. So
Oh, good.
that's a compliment. Boom. Boom. So I was going to do a live tonight to go over Well, of course, I don't have it at hand, right? That's what I was grabbing. But basically,
I don't want to deafen you.
no, you're
I
not.
don't
You're
want to
good.
deafen anybody.
You're good. You can talk.
Cheryl says, "Gee, sis, you don't have to deafen us. I must have really been bailing then."
Oh,
Sometimes I'm scared that I do talk too loud, and so I'm not sure how to moderate this thing. My
you can
voice.
turn the volume down. You can also go in. We might as well click it. Huh? Might as well work on it.
Brutus.
Hey, Brute, we hear you, dude. Okay, audio. It says automatically adjust mic volume. So if you do that in your StreamYard and the audio automatically adjust mic volume, it will level you out. So the only thing I don't have clicked in audio is stereo audio. Echo cancellation must be off to use stereo audio. Allegedly.
Can you hear me now? Is it better?
Yes. And just know that whenever you first turn your mic on, it's going to burst. So if you can turn, you know what I mean? Just something to remember. Another thing.
So it's better to use the mute button on here than it is the one on your mic, because it makes a noise when you click it on the one on the mic.
It goes click, click, click. Yep. It does.
Okay. I'll
But I
try
mean,
to
if
do
you
that.
have to, if you have a
I didn't
cough
know.
or sneeze or something, you can hit it. But it sounds so much better than just 10 minutes ago.
Oh boy.
I'm excited.
Wow.
We still gotta grease your chair though. Just stick it all through grease. Go bring it to the
Dip
car
it.
wash of grease. Yeah.
Dip
it.
Dip it.
Oh.
So Cheryl says, "I'm not being a pot stirrer." What's she saying? Because what is she saying here? Krisha's channel, after all. Krisha, your volume is perfect, sis. You sound better now. Thank you.
Does it? Good.
Good.
I only have mine turned halfway up. And that way maybe we won't overpower one another.
Or the
I noticed.
video. Because that's what
Right.
they said, that me and you were really loud and the video was not as loud. So maybe this will be a better situation.
Yeah. I know people bitch because I talk over it. And I'm like, what else am I don't want to stop every 2 seconds.
Really, you should talk over it when it comes down to it, because
it's commentary.
Yes, it is.
I'm looking for a new love. Okay. So basically what I wanted to go over tonight, and then we'll do another one Sunday night. I know. And we have members only tomorrow night for sure. About it's addressing Trisha Griffith and Lauren Matthias. We do not consent, right? So I was thinking about doing that tonight at 7:30 Central. And just join me live for a critical, direct discussion regarding the current media coverage of our family's case. We are addressing the latest actions and behaviors by Trisha Griffith of Web Sleuths and Lauren and Dr. John Matthias of Hidden True Crime. Despite our clear and public opposition, these platforms continue to ignore victims' families and exploit active trauma for content. Our position is firm and absolute. We do not consent. My family's pain is not your fundraising mascot. No is a complete sentence. No means no. The entire true crime community sees them for what they are, what they truly are, and turns their backs on them, just as the wider true crime community does to performative advocates who exploit victims. A dynamic. Oh wait, I'm reading the freaking visualization thing. Hold on. So skip that last part. So tonight we're going to trace these platforms that guide the public narrative. We're going to critically examine true crime media networks and brainstorm actionable community steps to demand ethical standards and protect families from ongoing media abuse. It's time for accountability in the digital research community. We are fighting to transform these tragedies into positive change and ensuring the legacies of JJ, Tylee, Tammy, Charles, and Joe endure. So there's that. And I made, let's see. I just kind of wanted to put my feelers out there first. The thumbnail is going to look something like that. Okay. Or more like this. This is going to be like after the crash out, after the 24-hour cheese whiz. Okay.
That's pretty good.
Yeah. I was like, I need that. I need that in my life. And then this one, I'm just going to throw it up for now, for Sunday no, actually I'm not. That one don't go there. Anyways. So yeah, I'm just trying to do some scheduling, blah, stuff that I hate doing. But would y'all be down?
Yeah.
And then Sunday we're going to talk about, I'm sorry, I didn't give you a chance to answer. I'm sorry. Sunday we're going to talk about basically do an overview of everything with the Christina, with the stalking injunction, the false stalking injunction.
Okay.
With that court case, and basically what we've learned from October 15th, 2025 for sure, because that's when most of us became aware that there was even anything going on. Some knew before,
Yes.
some whatever, but we're going to start there, and we're going to just kind of go over what we know, what we've learned since then, what's changed. I mean, I even did, y'all know how I use my LM Google notebooks, and I have one where I just plugged in the files from the actual court case, from Lauren versus Christina court case. And I want y'all to know that the audio overview for that is it leans completely towards Lauren. And it dawned on me, the biggest thing was Lauren prevented Christina from being heard. So of course it's going to be one-sided, and that's what the hell you're going to get. And that's what everybody, it just kind of clung on to. But what I have learned also is that they need to take that episode down for sure. A couple of them. All right. But they also need to apologize to the same size audience. Okay. It's got to have the same gravity. Okay. I've learned that too. And I'm like, yeah. Because you want it to have the same reach that your initial false statement and lies did, the harm. So anyways, welcome in. Hey, Morrissey. Hey, where'd that one go? Oh, wow. I just saw somebody's name and then I don't remember what it was. It's not there now. Weird. It's freaking me out.
And this,
So
what are they hiding? Putting this thing up here.
they're saving us from his hair. Okay.
That's true. And Brutus is scratching again, so I keep muting.
I
so
hear
y'all
him. No, he's fine. I don't think that bothers anybody. It doesn't bother me, but I'm not everybody. That's what I was thinking about doing. And you know how I said something about all Christmas till Christmas, kind of that theme? Well, I'm like, it can be Griftmas because it is. Okay. Griftmas in July.
Yeah.
And just, I've found other stories where this kind of thing has happened before, like with the Kardashians, with the Travis Scott incident over there at Astroworld, and I want to say, was it Houston? And how Kylie Jenner, after that, used that same theme for their child's birthday party with the big mouth, and they walk through it, like mocking it, not having any kind of compassion for what happened. People lost their lives, and here they are making it a party favor, like a bouncy house type thing, but you walk through it. I mean, anyways, so I'm gonna look for other stories like that where there's hypocrisy and just mocking of, or just being tone deaf, completely tone deaf. So Anyways, come on, Recess.
I'm saying, how long did it take you to watch this rogue video that's let the cat out of the bag to the whole world?
Mhm.
That's what they're acting like.
I know. I know they're so they're like so non-trusting of us little peasants, you know.
Well, to be honest, some of them do need to hush because they draw attention to themselves, and when their comments don't fit up with the timeline and other thing, they just
Mhm.
draw attention to themselves when they could have just shut up.
Yep, you're right. I mean, it's true. Yeah, I know. Let me say, I used to watch the Kardashians back in the day. I used to watch MTV. What are the names of the shows? I used to watch Teen Mom. Okay. I used to watch, oh my God, Spencer, whatever his name is, was in it. Shit. It was in Southern California. Oh my God. I can't think of it. I used to watch all them shows. I also Intervention. I watched that show, but I had to do that one in doses because it was heavy. And then Hoarders. That one I have to also be in the mood because oh my God.
Angela says to give Brutus a cool bath with oatmeal. So you just put oatmeal like you eat. Just throw some oatmeal in the tub with him.
Yeah, that's like a sit. Is it like a sitz bath or something? Like whenever I had chicken pox, that's what you do. Oatmeal bath.
Okay. Okay, I didn't know about that. So
If
yeah,
you
we'll
Google
try
it
that.
and AI will give you like good instructions. Usually, that's how I do. That's how I be rolling over here. And Angela says yes, it's safe. Cool. Poor baby. Yeah, I mean it helps stop the itch. Now that I think about it, because I mean scratching. Oh my God, it's the worst thing. You know, it makes it itch even more. It seems.
I know, and you can't. They're like babies. You can't make them stop. Just by saying don't scratch.
Yeah, I know. Yeah. Oh, I also learned Lamisa just reminded me. Whenever I put Dr. Patricia, I think, is it Patricia or Patrice? Anyways, Dr. Barry on YouTube. And it was about Rex Heuermann's alleged therapist, being charged with larceny, allegedly, or something, because she was practicing without having her license. And it made me think of Megan, and I know it depends state by state, but I'm gonna have to check into Texas and see if that's where she resides and see about what their protocol is. But she says it's very easy to verify if someone is verified or not. She said the Board of Psychology, and then she was like Psychology Today, they verify if one is licensed or not. These are just some notes I jotted down. Then there's the NPI, which is the National Provider Identification Number. She said they don't verify whether a person is licensed or not, but that's where you get it. But anyways, and she was just saying that you can get in trouble for the way she went at it was about if you're dealing with people's past traumas and things like that, you can't be a life coach. Okay, so anyways, there's just a lot of technicalities to it that I believe can really easily get taken advantage of, and do get easily taken advantage of. People, and innocent people who maybe can't afford it, but I don't know, maybe it's a lesser rate or something, and there's no oversight board. So Megan was like, okay, well, I haven't gotten any complaints. Well, we wouldn't know anyways if you lied. I mean, we can't see inside your damn mailbox, lady. It's weird. Oh, okay. Okay. Yeah, okay, good. So, right? No, she's not licensed. And he confessed. Oh my God. Yeah. So I have to go back and finish it because I just caught the very beginning of it. But it was interesting to kind of get that take on it. It would be interesting to find all these people on YouTube as well, because they're in there, you know, land of opportunities. Or the calamine lotion, yeah. I think that's what no, it was Benadryl. It was either calamine lotion or Benadryl that Trisha put on her face, pretending to be a face mask or whatever. Her idea of a face mask. Oh, she says, Lamisa's like, do not put calamine on your pets.
Okay.
So definitely do the oatmeal bath. Not lumpy.
I have not put any calamine lotion on him, but for a minute I did think about pulling that stuff called Calahist. It's like a Benadryl, but I won't do that either. She said, I'm kind of scared to put anything on him after what sick as he's been. I just scratch him. I do little scratchy signals, and he'll come sit by me to get scratched.
Nice to have you, A1 Way Street. Okay, finally I got it.
I wonder if Nate is saying why they're doing all this over there on X. I don't know.
Nate is being his regular dramatic self. He's like, oh, and they embraced, and not just for a what do you say, a short embrace. It was a long embrace, and they were weeping, and they left their Kleenex on the pew. I'm like, did you save them? I mean, what the fuck, dude? Like, what are you doing? He's doing that LDS thing.
Yeah.
Where they ingratiate. That's that ingratiation thing happening, I think, where they embellish. It's like, go read obituaries from LDS Mormons. Okay. They're like, oh my God, you need to play the sad music. I know obituaries are sad. Okay. But they go way, kind of like resumes. They go just as far. Okay. In my opinion. Oh, why you didn't tell me? Okay. Let me turn that shit up.
As well as everyone in attendance when it comes to constitutional
Sorry,
matters and balancing constitutional rights and transparency. This court will take the necessary time to make sure it's given the weight it deserves, and it is deserving of every moment that has been spent. Mr. Novak, turning to you. And perhaps before you begin, let me go ahead and make a record of what I noted that is at issue. And after I put this on the record, certainly if either side wishes to be heard about the court's understanding, I welcome your comments. Exhibit 24 was displayed on the monitor visible to the media camera. Exhibit 16 was displayed on all monitors and appeared on the live stream for approximately 3.5 seconds. The camera operator redirected the camera before any party called attention to the display of Exhibit 16. Approximately 16 seconds later, the court observed the image and stated, "Let me stop you, Mr. McBride. I'm not sure. Is this being broadcast?" Mr. McBride responded, "Let's take that down." The full text of Exhibit 16 had previously been made public through a search warrant that was publicly available on or before April 2026. The portion displayed on the monitors did not contain the full note and consisted of approximately 78 words. Approximately 15 of those words were included in the information filed on September 16th, 2026. In addition, the full note was read into the record during the preliminary hearing. The court previously ordered that Exhibit 16 be admitted into evidence and permitted its display within the courtroom, but prohibited its publication through the camera used for the live stream. And that concludes the findings of the court as it relates to this issue. Do the parties wish to be heard before we go into what you're requesting about the record on what occurred?
Your Honor, your recitation is accurate. My earlier comments were based on my memory of reviewing this last night. In the recess, I reviewed the feed again, and what you have said today is accurate.
Thank you. Mr. Novak, any?
No, Your Honor, I don't take issue with the court's factual summary.
All right. Turning to you, Mr. Novak.
Thank you, Your Honor. We're going to renew our request to exclude all electronic media coverage from all future proceedings. That was our motion docketed at number 305, and that included video cameras, still photography, and audio. This is the second time that the court's orders concerning the scope of electronic media coverage have been violated. I'm a baseball fan, and I just don't think the court needs to wait for the third strike. 2 strikes is enough. If I may, the alternative remedy, which we think is not wholly adequate, which is why we think it's an alternative and a less desirable alternative, is for this court to both reverse its prior order authorizing electronic media coverage of today's hearing, which we had previously filed an objection to after the court, I would say preliminarily granted the requests for today. That was sort of the chain of events. And that the court proactively preclude electronic media coverage at the last day of the preliminary hearing, which will be September 1st. Now, I understand that there has not yet been a request for electronic media coverage for September 1st, but there is no doubt that there will be, just as this court previously observed that it wasn't prepared to preclude electronic media coverage at the preliminary hearing because there had not been any requests. There were requests, and those that were timely were all granted. The court denied one request because it was not timely for one particular day. So I guess the way it would be is any request for electronic media coverage of September 1st will be denied because that's the appropriate sanction for what happened yesterday. The fact that the content of the exhibit was previously summarized by the state in certain documents which became public because the state didn't take any actions to seal them beyond the 6-month period. The fact that the contents of the exhibit were read in open court is not the issue. The issue is when the court issues an order, everybody must comply with it, and there are reasons for the order. And the reasons, as this court stated, are to protect Mr. Robinson's right to a fair trial. So no doubt that the court balanced those prior ways in which the content of this exhibit had already been disclosed when the court decided that there would not be electronic media coverage. That's a fact that we have all known of that exhibit. That's a fact that we've all been aware of as we've gone along. So to summarize, and then I will stop because I know we still have a witness here, and of course the court needs to hear from the state and counsel for the media, I suspect, is we would like the court to reconsider its order denying motion 305 and grant it for the balance of all of the proceedings in this matter, or as an alternative, the court prohibit any further electronic media coverage of the preliminary hearing, which includes September 1st.
Thank you, Mr. Novak.
Thank you very, very much.
Turning to the state and then to the media.
Yes, Your Honor. As to the remedy, we've heard of instances where the media has been able to delay publication of the recordings of the proceedings. We've heard of instances where that has been a short delay of like 30 seconds. I've talked to the media attorney about this, and they do not have the capability to do that right now. My suggestion would be for future proceedings to order the media to look into that capability, and that would be a remedy that perhaps could be used in the future. I think that would be a satisfactory remedy to avoid this type of thing in the future. As to the other remedies requested, we have one witness. The final witness, well, the defense has one witness. That witness is a ATF DNA forensic biologist. And I assume that the exhibits that will be admitted through her will be of that nature. We've already, in fact, admitted the report that she is going to be testifying to. The reports, I should say, that's exhibits 30 and I believe 34. And so I don't think we have, and those have already been published. I don't think we have the same risks or, I'll just say risks with her testimony as we do with some of this other evidence that has already been admitted.
Thank you. To the media.
In a proceeding like this, the parties in the court and the media are working together to learn and to refine their processes. I hear Mr. Novak's remarks about challenges that we've run into in the past. I recall, it hasn't been that long ago, a time when the camera was placed in a location in the courtroom that was causing challenges. The court moved it. When there were challenges with aspects of the court's ruling, the court reiterated those, and those processes improved. We are getting better at this. Media is on board and recognizes the court's obligation and its significant efforts to balance the interests here. In light of the court's ruling, including its recognition that the media operator in this case beat almost all of us to the punch, right? And saw what was happening on the screen and moved away as quickly as they could. We believe that the procedures that the court currently has in place, even if they don't every moment of every hearing deliver the result that we are intending to deliver, those processes are working. I don't believe that a further adjustment, much less a sanction, much less a revisitation of something that says let's keep every photographer, every camera out of this courtroom for every proceeding. In light of the court's well-reasoned and exhaustive rulings after long briefing on all of this, the court is currently balancing these interests correctly, and we therefore ask the court to allow the parties to recognize that the time we're dedicating this morning represents a reiteration of the importance of these principles. The media and the parties all recognize that. We'll continue to endeavor at all times to do all that we can to ensure that those are adhered to, and let the parties go forward under the current procedures without further order or sanction by the court.
Thank you. Any further arguments before the court issues its ruling?
No, but thank you for the opportunity.
Thank you. And just updating my notes as I'm intending to issue this ruling right now. I'm just making sure that I'm capturing all the points made in the argument right now.
Oh, Thumper. This is weird. Doody 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 doo. I know, I just boosted it more all the way up. So hopefully no loud, burst. Beach Bum said, let me find it. She said, wait till they get the idea to stop live chat like one judge did. Can you imagine? They cannot stand to hear about their crimes, man. Stop committing them. And she says delay, no tweeting, etc. Yeah, they had Lori's on a 1 hour or 30-minute delay for one of them, or the ones in Arizona. The camera in the back of the courtroom, one camera. They could zoom in, but blah, 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 all the things. What if they made a courtroom big enough for us to all go? They know they can't. So he seems to be, typing. Maybe we can have someone doing Morse code, but with a 24-hour delay. How about we all just turn this shit off and not give a shit? And they'll be like, oh, damn, how are we going to control their emotions now? Oh, right. Yeah, that's that. Dun, dun, dun. Breaking news. Yeah. Yep. Man, I hope not. Right? It's the best camera out there. I debated. I was like, yeah, fuck it. That's what it feels like. And it even has a delay. Okay. The Viewmaster has a delay. 17 years. Oh my God, today. Today, Junior. What else they got? I'm looking at the images for cameras. I didn't know what the name of it was, so I was sitting there. 80s camera for kids. Oh my gosh, he types. I'm very jealous, actually. I used to be able to type like that. It went away. Okay. My eyes are dry.
All right.
Oh my gosh. Come on. Drum roll. Nope, not yet.
I'm almost done. I appreciate the party's patience. This issue rises to the level that necessitates great care. And as my practice, I don't like to rush.
We know.
Or make snap decisions. And I want to give this the full analysis that it's due. So thank you again for your patience.
Added some things, okay? Oh my Lord. Ooh, how about that? Let me turn that shit down. Pattel's in the corner, death signing. Oh my God.
There's no stalking. No one would want to stalk that ugly bitch.
All right, I need to get out of here.
All right. Court will issue its ruling on the request by defense.
Mm.
The constitutional rights of Mr. Robinson and Ms. Kirk are paramount. Although transparency in judicial proceedings is a fundamental interest, it must be balanced against the constitutional rights of all parties. Having considered the arguments presented by counsel and having reviewed the events that occurred yesterday, the court finds that its order prohibiting the publication or broadcast of Exhibit 16 by the media camera was violated. The court agrees with the defense that this constituted a violation of the court's order. Compliance with court orders is essential in all proceedings and is of particular importance given the nature of these proceedings. With respect to defense's request as a sanction that the court reverse its ruling on defense motion 305, motion to exclude cameras, the request is respectfully denied. The analysis underlying the court's prior ruling remains unchanged, and the court adheres to its reasoning and conclusions. With respects to the defense's alternative request as a sanction to prohibit all cameras and electronic equipment from today's proceedings, thereby preventing the electronic capture of the proceedings for those inside and outside of the courtroom, the request is granted in part and denied in part. Effective immediately, members of the media shall no longer capture or broadcast any exhibits displayed by the parties during today's proceedings. The court finds this sanction to be proportional and appropriate in light of the violation of the court's prior order. The court reserves this sanction as it relates to September 1st. It is not before the court. There has not been a request for electronic media coverage, and the court won't issue a pre-ruling. When it becomes, that request has been filed and all the deadlines which the court has imposed in regards to the MC filing are in place, if motions are filed, the court will entertain motions in brief argument ahead of the September 1st hearing and address it at that time. This is the ruling of the court. Thank you. Turning to the defense, if you wish, you may call your next witness.
Judge, we would like the benefit of the record before we start taking evidence today.
Yes, Mr. Grenander, and I'll allow all parties, given the ruling of the court, briefly.
And I'll be brief, Judge. And this is in relation to the continued taking of evidence today. And I'll start my statement, Judge, with something that was very insightful that you said the other day. You mentioned, and I quote, "Sometimes you need to take time to save time," close quote. And so that's my purpose for standing up here this morning. We have spent the better part of a day, a little over 5 hours, I believe, hearing from witnesses that the defense has called at this preliminary hearing. And no doubt the defense is entitled to call witnesses at a preliminary hearing as allowed by the rules. But I think it's important that the court remind all parties about the purpose of this hearing. This is a probable cause hearing, as Your Honor has repeatedly stated. The defense has invoked the term reliability many times. And the court, frankly, has found the evidence that's been admitted, the testimony. As a gatekeeper, the court has found it reliable. It's been presented. The exhibits have been found reliable. So any questions of additional reliability are really questions of credibility of the witness and weighing of the evidence. And that is not really what this court engages in at the probable cause standard. And so this is all couched in the context of a likely forthcoming standing objection that the state may lodge if the testimony is long and drawn out and exceeds the scope of the preliminary hearing, gets into areas of a 702 hearing, possibly even trial. We will lodge this objection, but I wanted to just simply state the authority, Judge, behind our objection if we do make that. As your court is well aware, the magistrate at this stage of the case must view the evidence in the light most favorable to the prosecution. And that's cited to in a number of Utah cases to include State v. Schmidt. Schmidt continues, "This means that when reasonable inferences from the evidence cut both for and against the state's case, the magistrate lacks the discretion to choose between them and must leave such a determination to the fact finder at trial." A few other cases I would like to refer the court to. State v. Pledger, which is a Utah 1995 Supreme Court case. Speaking of this standard, the court says, "The standard bars the magistrate from requiring the prosecution to address or even eliminate alternative inferences that could be drawn from the evidence in favor of the defense." So even assuming the defense scores points today in calling these witnesses, again, the court cannot really weigh those in favor of the defense. State v. Hester, which is a Utah Court of Appeals case 2000, where there is conflicting evidence, quote, "The magistrate may not sift or weigh the evidence, but must leave those tasks to the fact finder at trial." Of course, we're not at trial yet. State v. Virgin, a Utah 2006 Supreme Court case, indicates that a magistrate may only disregard evidence at a preliminary hearing if it is, quote, "so contradictory, inconsistent, or unbelievable that it is unreasonable to base belief of an element of the prosecution's claim on that evidence. There's a State v. Drozbecki case, which is a Utah Court of Appeals case, 2010. Magistrates may only disregard or discredit evidence that is wholly lacking and incapable of creating a reasonable inference regarding a portion of the prosecution's claim, but must leave all the weighing of credible but conflicting evidence to the trier of fact. And finally, State v. Lopez, a Utah 2020 Supreme Court case. Speaking of this probable cause standard at a preliminary hearing, the court said, under this low bar, it may be difficult for the defense to overcome a prima facie showing of probable cause. Even an alleged victim's recantations may sometimes be insufficient, given that the magistrate must view all evidence in the light most favorable to the prosecution and draw all reasonable inferences in favor of the prosecution, close quote. Judge, Your Honor has heard 4 days of testimony now. The evidence is overwhelming. It's devastating. And the question needs to be asked, the purpose of continuing with testimony if it's long and drawn out. Of course, the defense has the right to call witnesses, but it needs to be within the context of this preliminary hearing. So again, we may be lodging a standing objection of relevance and exceeding the scope of this hearing. That's my record.
Thank you, Mr. Grunander. Do other of the parties wish to be heard as it relates to Mr. Grunander's statement? To the defense?
Is that you?
I'm not sure what was being requested by Mr. Grunlander. As I indicated to the court during the testimony of the last witness, we had discussion with the state prior to the start. We had a scheduled date for the court to rule on objections. And the purpose of that hearing was so that we wouldn't have to fly witnesses out from the East Coast if there was going to be a standing objection. Prior to that hearing taking place, the state contacted us after they had participated in interviews of Ms. Oliver and the other experts, and indicated to us, and we indicated to the court, that there was going to be no standing objection to the testimony of these witnesses. So if he's lodging a standing objection now, I think he's
John.
waived it, or he should be stopped from asserting it given the circumstances. I didn't hear that he was asserting that, and I intend to keep this next witness focused on the issue that I think is relevant, which is the state presented DNA reports through a non-expert. They selectively read into the record a portion of those reports, which left an extremely misleading impression of the significance of that evidence. So I have the author of the report here, and I'm going to hopefully educate the court on what the limitations are of the report, and that's it. I hope to be done with the witness by noon, direct and cross, and
Let him in.
All right, thank you, Mr. Burton.
Do it,
Before I,
lady.
have you call the witness, just want to make sure that the media I'm not sure if the media needs to be heard on Mr. Grunander's response. All right, thank you. All right, Mr. Burt, you may call your next witness.
thank you. Call Miss Oliver.
Ms. Oliver, if you'd like to come forward and be sworn in.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
All right, ma'am, you may be seated. And there's a water bottle to your left if you wish. And after you're seated, if you wouldn't mind adjusting that microphone, bringing it close to you to pick up your testimony from today.
Y'all, what's her expertise?
Thank you. Could you tell us your name, please?
Caitlin Oliver, Oliver.
And Miss Oliver, could you bring that mic a little bit closer? So I want to make sure your voice is projected. Thank you. What do you do for a living?
I work for the Bureau of Alcohol, Tobacco, Firearms, and Explosives as a DNA section chief.
And how long have you held that position?
I've been a section chief since January, and I've worked with the ATF for about 9 years. Prior to that, I was a forensic biologist.
And where were you a biologist before you started to work for the ATF?
Prior to the ATF, I worked for Jefferson Parish Sheriff's Office in New Orleans, Louisiana, as a DNA analyst and a DNA quality manager.
Whoop, whoop.
Back in September of 2025, what were your duties and responsibilities?
I was a forensic biologist.
And do you recall that around September 11th, you received a request to do some DNA work at the request of the state of Utah?
Yes.
Could we display State's Exhibit 30, which is in evidence?
Oh shit, it went mute. Here we go. They didn't cut us off. Jefferson Parish, Jefferson, did they say Jefferson Davis Parish? Because that's right here. That's whenever Trahan turned it into Trahan. Them cool nasses, yes, yeah. They're like, Trahan? I'm like, never heard of that. That's them Yankees. Just kidding. What the fudge? Turn it up. You're right, Judge. We can't handle it. We can't handle the truth. We can't. We can't handle the truth of the matter. All right, let me Google something. I need her, whatever the hell she does. AI mode. Let's see. Caitlin Oliver, a forensic biology expert with background ties to Louisiana law enforcement, which, if it is Jefferson Davis Parish, then that would be like where the Jennings 8 happened. Okay. She currently serves as a forensic biologist for the Federal Bureau of Alcohol, Tobacco, Firearms, and Explosives, or ATF, a position she has held since December 2017. Louisiana law enforcement roots. Prior to her federal role, she worked in Louisiana for 5 years, November 2012 to 2017, as a DNA analyst for the Jefferson Parish Sheriff's Office. No, don't look at your note mentions. Okay, whatever. But public professional records indicate her local DNA work was based out of Jefferson Parish. There's Jefferson Davis and Jefferson. Why they want to do that? I don't know my parishes anymore. So it's over there by New Orleans, by Donna. It is very common for outside databases or references to, okay, so I just threw in some info and then it's correcting me. So that's what it's doing. I want to hear, hey, do we have captions? No. I always wonder if they're going to slip up one day and give us some captions. Blink 3 times. That's what my people are saying, Judge. He's watching funniest home videos. Okay, well, I'm just going to be over here decorating, doing my work. Yeah, because I gotta get that scheduled. Shit. Ooh. Sorry, I didn't mean to get loud.
For instance, the next sample down 1.2, where the statement paragraph D, admitted paragraph.
Oh, it's fluttering again.
You state in F, based on this calculation, there is evidentiary support for the inclusion of Tyler Robinson, correct? As a possible contributor.
Correct.
Mr. Burt, I just want to interrupt.
Sure.
I was made aware of a question about the media as it reflects this order. So the question was whether audio could be transmitted, and my ruling covered the video display of any exhibits. And so I just want to make sure that's the understanding of all the parties, that the audio of your portion discussing evidence is that you understand that that's going to be captured by the camera and displayed, but not any exhibits displayed Is that your understanding?
That is my understanding of the court's ruling, yes.
And to the state
Yes.
and to the media?
Yes, Your Honor, there might be concern about the actual monitors at council table and podium.
Well, that's why I give my notation to begin the morning that the parties are responsible to monitor their monitors. And that's there because they're entitled to view it, but they're responsible to ensure that the monitors, as the camera is picking up the courtroom, it's directed not to focus on the monitors, but inevitable capture may occur. And that's why that instruction is given.
Your Honor, Jeff Nye on behalf of the victim representative. We cannot see the court from where we are sitting, so I don't know if there's a way for us to view the monitor.
I don't understand what you're saying.
It's not being published on this
It's not
one.
being published on the monitor to the court's right.
Right, the order of the court based as a sanction is no exhibits will be displayed.
In the courtroom entirety?
As it stands right now, yes, that's correct.
Well,
Okay, please approach the lectern.
Your Honor, it's just hard for the victim's family to be able to follow the evidence if everyone but the victim's family is able to view the exhibits here in court.
Thank you, I appreciate your concern. This monitor is not on either. So it's only the attorneys. The attorneys have a right to view what exhibits are being displayed, to make their motions, objections, and to see it. It is the court's discretion on what's displayed in the courtroom for publication, and the court issued a sanction given the events of yesterday, and that's the court's ruling.
Your Honor, I just asked the court to consider the victim has the right to be present, obviously, at the hearing. And the presence without being able to see the exhibits, again, it's our position, is not meaningful.
Thank you, I appreciate your concerns. Mr. Burke.
Could you redisplay exhibit 30, please? And again, while he's doing that, that same conclusion where you include the language, go back to that page, please, 5. Use the term, there is evidentiary support and possible contributor. I want to focus your attention on the words evidentiary support. We've had a prior witness testify that from the FBI testified that they use a scale and they characterize the support along the lines of strong. Are you familiar with that type of a scale?
Yes,
Does your agency employ that scale?
we can come to 5 conclusions at our agency. So there can either be exclusion, limited support for exclusion, uninformative, limited support for inclusion, and support for inclusion.
And I take it from what you just said, you don't use these qualifiers strongly. The word strongly include things of that nature.
Yes, we don't use a verbal scale at our laboratory.
Is that a scientific phrase when you talk about instead of saying that there's support for an inclusion, you instead say there is strong support for the conclusion?
So our laboratory doesn't use a verbal scale due to the fact that they add subjective words to the front of this word support. It is our stance that the likelihood ratio statistic, the number stands on its own. So we report the likelihood ratio and either support for inclusion or support for exclusion.
Thank you. Would you go to page 8 of the report and highlight the very top of the first 2 sentences? You included this language in your report, correct?
Correct.
And in fact, you included this language in all 3 of your reports, referring to the conclusions conform with the relevant Department of Justice policy on uniform language.
That's correct.
Right. And why do you include that language in all 3 of your reports?
It's standard language for our reports. Our reports adhere to the DOJ Ultra statement.
Okay. And could you go now to exhibit Oliver 4 for the witness only. Not admitted yet. Are you familiar with this document, the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examination using probabilistic genotyping systems?
Yes, I am.
Right. And would you go to page 4 of that document, please? And the court has heard some prior testimony about this Department of Justice directive. What is ATF's, what is your understanding of what the qualifications and limitations are that are required by this policy of the Department of Justice? What are you not supposed to be saying in connection with the reports that you wrote in this case?
There's a few things that the Ultra document states. First, it states if you use a verbal scale, which we do not, then you need to use the one dictated in the document. This is in an effort to unify the language coming out of DOJ laboratories. It also says that we cannot state that our evidence is infallible, nor can we state that there is a inconclusive result.
Shall not state that it's infallible or have a 0 error rate, correct?
Correct.
It also states, does it not, that you shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample.
Correct.
And are your reports in conformity with that? You're not stating or implying that anything you did here is asserting an absolute identification of someone as the source of any of the evidence that you examined, correct?
Correct. With forensic evidence, it's impossible to state with 100% certainty anything. That's why we report a likelihood ratio, to speak to that uncertainty with a statistic.
All right, and would you go to the next page of that document? This policy requires that you not state or use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty. You didn't do that in any of your reports, correct?
Correct.
You're not asserting anything with respect to any reasonable degree of scientific certainty.
Correct.
Correct. Now, when you can take that down, when did you first receive the assignment in this case?
I would have to refer to my case record to know the exact date.
Do you have those in front of you?
I do not.
Okay, let me pull up Oliver 3 for the witness only. And go to the third page. Does that third page help refresh your memory on when you may have received this case?
Yes, on September 12th, 2025.
Okay. Is that when you first started doing work on the case, do you think?
Yes, it is.
Now, prior to doing work on the case, did you receive permission from someone to consume any samples in the case?
Yes, I did.
And could you go to page 15 of those case notes, please? Again, for the witness only. Do you recognize this email?
Yes, I do.
And can you tell me what the email is and what information it conveyed to you in connection with your examination?
Yeah, so it's standard procedure at our laboratory that when we receive a case, we request permission to consume from the agent. We request that they reach out to an attorney if one is assigned. In this case, we will not begin any work on the case until we've received that permission to consume. So this email is us receiving permission to consume the samples and move forward with testing.
Now, does your lab have a policy for preserving samples for independent testing by the defense?
Where possible, we will not consume samples where it's possible.
And that policy is a longstanding one, not only in your lab, but pretty much everywhere in forensic DNA analysis, right?
That's correct.
Goes back to 1996, does it not, when the National NRC recommended a policy that samples be split wherever possible at the front end of the analysis to allow for independent examination.
Where possible, yes, that's correct.
Right. And they did that because it was their conclusion, was it not, that a wrongfully accused person's best insurance against a possibility of being falsely incriminated is the opportunity to have the testing repeated. Such an opportunity should be provided whenever feasible.
Correct.
Okay. Could you now go back to Exhibit 30? Page 8. Were certain DNA samples consumed in your analysis?
Yes, they were.
And for the record, are those listed on page 8 of your report?
Yes, they are.
Which samples were entirely consumed in your analysis?
That would be exhibits 1.4, 1.6, 1.9, 1.10, 1.12, 2.1, 3.1, 4.1, and 5.1.
Okay. Then are there a number of samples listed above there in the report where you say the DNA extracts will be retained? And then you list 1.1, 1.2, 1.3, 1.5, 1.7, 1.8, 1.13, 7.1, and 8.1.
Correct.
Does that mean that those are all swab samples, correct?
They were swabs, yes.
All right. Does your report mean that you consume the swabs, but you have some liquid extract remaining as to those samples?
Correct.
Now, are all of the samples, let's talk about the samples in Plaintiff's Exhibit 30. Were all of the samples you looked at there mixed samples?
I refer to my tables in my report.
Sure. Go to page 2, please.
And can we go to page 3 and 4?
3 and 4, please.
With the exception of the known samples from the known individual, that was a single source sample, but otherwise the evidence samples were all mixtures.
And in many cases, they were mixtures of sometimes 4 and 5 people, correct?
Correct.
Now, when you look at mixtures, such as the ones in this case, you use terms like major and minor contributor, right?
Correct.
Is that language meant to convey that anything with respect to activity of anybody who might be assigned to that DNA weight? In other words, are you saying the person you label as a major contributor was engaged in any sort of activity? Is there any connection between the use of that language and activity?
None of the testing that I performed could speak to activity or what activity led to the deposition of the DNA.
So nothing in your report, if somebody reads that and says, oh, this one says this person is a major contributor, you're not commenting on anything about the person's activity, correct?
Correct.
And is it true also that there are also several other limitations concerning the language of your report that it's important for courts and people who are reading the report to understand?
I'm sorry, what was the question?
Are there other limitations in addition to the one we just reviewed that it's important to understand about the language you use in your report?
In terms, is there something specific that you're?
Yeah, there is. Could you go to Baker Exhibit 30, page 1, for the witness only. Are you familiar with this publication?
Yes,
This is a publication by the National Institute of Standards and Technology called Forensic DNA Interpretation and Human Factors.
correct.
This is put together as a guidance document for practitioners on what, to simplify essentially what to say and what not to say.
I don't know that I would call it a guidance document. NIST is not a regulatory body for DNA testing. It was a report that looked into forensic DNA reporting and specific human factors that could affect our testing. So they may have had recommendations, but as far as them being a regulatory body that's issuing guidelines, I wouldn't state that.
Okay, that's fine. Could you go to 136, please? $136. This is Baker 30. Keep going. There we go, right there. Wait, 135, I'm sorry. And then scroll down to the next page. So they're making recommendations here as to how the report should be worded, correct?
Correct.
Let me ask you whether you agree with some of these limitations, or they call them caveats. They talk about how you describe the number of contributors, and they say the true number of contributors of DNA to an item can never be known. Do you agree with that?
Yes.
Okay. They also say, let me ask one question before I ask this one, which is, do you use something called a reporting cap in all three of your reports?
Yes, so for our likelihood ratio statistics, we cap the statistic at 1 trillion. The actual number could be a lot higher. It could be quintillion, octillion. We chose 1 trillion because it has meaning, I think, to people that can understand what 1 trillion is. An octillion and a quintillion gets a little high at that point, so we cap at 1 trillion.
And they talk here, do they not, about how you convey the idea of a reporting cap? And they say the LR reporting cap was chosen because of the limitation of biostatistical modeling and independence assumptions of STR loci. Do you agree that that's why the cap is chosen?
I believe we chose our cap for the reason I stated.
Do you disagree with that statement in terms of why the cap is chosen?
I'm not familiar with the paper that's referenced there, so I would have to familiarize myself before I said I
Okay.
agreed or disagreed.
Fair enough. And then they also suggest that you alert in your report that profile descriptors cannot be applied to activity level issues. Do you agree with that?
Yes, so this is what you were stating about calling a major contributor. It doesn't speak to the activity that led to the DNA deposition.
Right. DNA profiles may be described as major, minor. However, these descriptors should not be interpreted in the context of a decision regarding the nature or the mechanisms, actions, or timing that led to the deposition of the DNA. You agree with that?
Correct, yes.
All right. And then the other sort of limitation, convey that the DNA results cannot be interpreted as the analyst providing an opinion regarding who the source of the DNA is.
Yes, so this is once again, we don't make source attribution statements. We will say there's support for inclusion, and then we back up that with a statistic.
So from a scientific standpoint, you couldn't read the paragraph that sets out the likelihood ratio in your report, whatever the number, and then blast a headline in the media, Mr. Robinson's DNA is found on this item. That's a source attribution, is it not?
Correct, yes.
And that would not be scientifically defensible, would it?
Correct.
Okay. Another limitation they talk about on likelihood ratios on the next page, please, 137. Likelihood ratios cannot speak to the likelihood of a proposition, only to the probability of the results given a pair of propositions. Do you agree with that?
Yes.
Explain that, because that's a little above my pay grade in terms of understanding.
So a likelihood ratio statistic compares the probability of the DNA profile of the evidence given two competing hypotheses or two competing scenarios. Typically, the first is that the person of interest is included, and then the exclusionary hypothesis would be that the person of interest is excluded. So there's a random, unknown, unrelated individual contributing.
And when they're elaborating on that point, they say a likelihood ratio indicates if and to what extent the DNA analysis results support one proposition over another. It is not possible on this basis alone to determine which is the most probable proposition. Do you agree with that?
Yes.
Okay. And then the next limitation they suggest you convey is that convey that DNA statistics cannot imply uniqueness within a population. Do you agree that that's a legitimate limitation?
Yes.
And explain what that means. Does that go back to the issue of source? You can't assign a source to a DNA sample?
Correct.
Okay. It says you should delineate the meaning of a verbal qualifier, but you didn't use one in this case, right?
Correct.
Okay. Now, you mentioned that your testing cannot, and correct me if I'm wrong, I don't want to mischaracterize it. Your testing, none of the testing in any of the three reports can answer the question of how and when DNA got deposited. Is that true?
That is true. DNA can't speak to the activity that led to the deposition of the DNA.
And the report says, with regard to that issue, with the increased sensitivity of DNA techniques and sophisticated software, a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swapped. Alternatively, a person's DNA may be present when they were not involved in the crime. Do you agree with that?
Yes, once again, I cannot speak to the activity.
Can you explain how it's possible that a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swapped?
So it's possible if, say, the pen that you're sitting there using for the week, you say hand it off to the judge, and the judge then touches it for a period of time, and then I swab it. It doesn't speak to who handled it last. I could test that. I could get both of your profiles. I wouldn't know which person was the last person to handle that item.
All right. And similarly, if you had a lot of DNA on your hand, we shook hands. I then went to pick up an exhibit, a gun. I touched the trigger of it. Your DNA could be on that trigger, right?
It is possible, yes.
Okay, even though you never touched the gun.
Yes.
And that's why, because of those possibilities, you can't make any assessment of how or when DNA got deposited, correct?
Correct.
How long can DNA persist on an item?
DNA is quite stable over time. It can be broken down due to environmental insults. So things like heat and humidity are known to break down DNA over time. But I couldn't give you an exact number.
Were certain of the samples that you tested in this case degraded samples?
There was degradation present in some of the samples.
And what can cause degradation?
Like I said, there's environmental insults, heat, humidity.
Now, the second report that you wrote had to do with a Dremel item that was taken from Mr. Robinson's home.
Correct.
And did you request certain what are called elimination samples in regard to items that were recovered from his home?
Yes.
Tell the court what an elimination sample is as opposed to a sample that relates to what's called a POI, person of interest.
So an elimination sample is a sample taken from a known individual that it may be assumed that they could have come into contact with it. If I were to say swab your vehicle, then I would want your DNA sample as an elimination to eliminate you in order to look for any additional DNA that may be there.
And you say they're assumed contributors because depending upon the location, for instance, somebody's house, you would expect if there were multiple people in that house that perhaps everybody in the house could contribute to a certain DNA result.
It's possible.
So you'd want samples from all those folks to see if they contributed to an item that would be associated with a place where they congregated.
Correct.
And I noticed from your case file that you also requested, but I don't think you received, elimination samples from agents who were involved in this case.
Correct.
Why do you request those samples?
The type of testing we perform is quite sensitive. And so it is a standard practice that we request elimination samples from any of the investigators involved in order to potentially eliminate them in case they could have contaminated the evidence.
Okay. Now, in report number 157, if you could bring that up, please. Oliver 157, which has been admitted. The elimination samples that you requested in connection with items seized from Mr. Robinson's apartment were from Amber Robinson, Matthew Robinson, and Lance Twigs, correct?
Correct.
And that's because you had information that those people were associated with the house.
Correct.
And when you tested or compared, first of all, you determined their DNA types, right?
Correct.
Then you compared their types to what you found on the evidence.
Correct.
And for a certain number of those samples, you found the presence of DNA of your elimination samples, not because they were suspects, but because they were associated with the premises, right?
There was support for inclusion of some of these individuals, yes.
Okay. And if you could scroll down to page 4, which is the table, I just want to review briefly with you. For instance, item number 1.4, which was a swab from the rifle. You used the elimination sample of Mr. Robinson's father, and you found his DNA on that particular swab, correct?
I would say there was support for inclusion of Matthew Robinson on the sample obtained from the swabs of the bolts of the rifle.
I'm glad you pointed that out. That's, again, consistent with your other testimony. You're talking again about support for inclusion as a possible contributor.
Correct. And
Again, not because he's a suspect, but because he's associated with that premise.
correct. And there would have been a likelihood ratio statistic calculated and to go along with that.
Okay, Could you go to the next page? Similarly, with respect to 1.6, you found, again, Matthew Robinson on swap number 1.6, or a profile that indicated he was a possible contributor.
There's support for inclusion of Matthew Robinson.
Okay. And next page, actually go to page 7. You found support for inclusion of Lance Twiggs on swabs of buttons of a Dremel tool, correct?
Correct.
And going back to what we were talking about before, if a person named Lance Twiggs lived in that residence, came into contact with Tyler Robinson, and then touched a button on a Dremel tool, you'd expect Mr. Robinson and Mr. Twiggs's DNA to be on there, right? Or you could.
It's reasonable to assume that anyone living in the household could have contributed to DNA on an object found in that household.
And similarly, you found profiles to suggest support for inclusion of Mr. Twiggs on other areas of the Dremel tool, correct?
Correct.
Okay. Now, the last area I want to ask you about is, you're familiar with something called NGS?
Yes.
What is NGS?
NGS stands for Next Generation Sequencing. It's a DNA technique that sequences your DNA. So it looks at the individual sequence of your DNA.
And is it true that in your field, that whole area of NGS is something that's at the forefront of everybody's attention? For instance, when you go to seminars and you look at the presentations, there's a lot of talk about NGS, right?
That's correct. Yes, it's a newer technique.
And is it being developed by ATF as a technique that's going to be used or has been used?
Not at this time, no.
And is there plans to do that?
Not at this time, no.
Okay. Do you know if other labs have implemented it?
I believe there may be some laboratories in the United States that have it in use, but I wouldn't have direct knowledge of that.
Now, you used a program in this case called STR Mix, correct?
Correct.
And that's sold by a company in New Zealand, that software?
Correct.
Have they developed another program called STR Mix NGS?
I'm not aware of NGS software.
Could you go to 156, Oliver 156? Let me know when you're there. Are you aware that the developers are selling a product called STR Mix NGS?
I was not aware, no.
Okay. Now, sequencing analysis is different than what you did in this case, correct?
Correct.
And how so?
As I said, sequencing is looking at the individual sequence, the individual bases that make up your DNA, as opposed to the testing that I'm performing, which is looking at length variations. So STR testing, which is the testing I perform, looks at areas of the DNA that are known to be highly variable between individuals. And there are areas where the DNA sequence repeats itself over and over again. And depending on who you are as an individual, you may have a different number of repeats present at that location. So the testing we're performing is looking at those length variations. There's a distinction between, say, if you have 10 repeats versus 12 repeats.
But you're not looking within those lengths to see what the sequence of the DNA is.
Correct.
And that's what this new technology is designed to look at.
Correct.
And the reason it's designed to look at that is because it's been found that there are DNA areas that are different in sequence, even though they're the same length. Is that true?
I think the reason for developing NGS software is to add another tool to a forensic biologist tool belt.
Okay. Now, could you go to 154, please, for the witness only? You're familiar with this chart?
Yes.
Okay, this lists all the alleles that you found for all the testing in your 3 analysis, correct?
No, it looks like,
No, you were right, 154. Yeah, this is one. What's the exhibit on this? Okay. You're familiar with this chart, right?
I reviewed the first page of this chart. I have
Sure.
not reviewed the entire
Go to the
thing.
first page. This lists the alleles that you found, correct?
For the known samples, yes.
Okay, now go to the second page. And is it true that for the alleles of interest in this case, one of the alleles of interest is at the D3 location, allele 17?
One of the locations that we look at on the DNA strand is called D3. That's a location, yes.
Right, and in this case, the 17 allele is important because Mr. Robinson had a 17 allele, correct?
Correct.
And some of the evidence had a 17 allele
Correct.
at that location.
Correct.
So as I understand the way you do this, you look and compare whether those are the same number, basically.
I wouldn't state that's how we do our comparison. So it's not just number matching. We're using STRmix, the StarMix software, in order to perform an analysis of the software that looks at the possibilities for a DNA profile and make comparison to the knowns that way. We aren't using a chart and just doing number matching.
Yeah, and I wasn't suggesting you did, but you're looking at the alleles and measuring the peaks, and it's a fairly sophisticated process, correct?
Correct.
But the bottom line is you're comparing alleles one against another.
Correct.
So if a person is a 17-17 and the evidence sample is a 17-17, you're looking at that comparison.
Correct.
And again, measuring only length.
Correct.
But it's true, is it not, that researchers have found that that particular allele, the D317 allele, that there are actually 3 different 17s, 17A, 17B, 17C.
Yeah, so there's something known as isoalleles. What that is you may have, in this case, a 17 allele, but the sequence within that 17 allele is different. So 2 people may have a 17, but they may have a different sequence within their 17 allele.
And it's been found that there is a 17A, a 17B, and a 17C, correct?
Objection. Relevance to the probable cause hearing. At this point, I think we've once again gone beyond probable cause, and based on Mr. Grunlander's argument, I would invoke his argument here in the case law that he referenced, and I object to this question.
Let me withdraw the question, reframe it, and move beyond it.
All right, so I'll sustain the objection. It will be reframed and we'll go from there.
It's true, is it not, that at least 1, 2, 3, 5 of the locations of interest in this case, researchers have found that the alleles that you were looking at, these isoalleles, have different sequences but the same length.
Objection. Relevance. The witness has testified she does not do sequencing analysis here, and that's what the question is asking, is about sequencing analysis.
Counsel?
The point, though, is that her testing cannot distinguish between these isoalleles, and therefore it goes to the weight of the comparisons.
But if she didn't do that,
Yeah, that's the point, is that she didn't do it, and therefore she's not in a position to draw conclusions.
Mr. McBride?
That proffer is inaccurate, that she's not able to draw conclusions because she did not do NGS or sequencing analysis. She has testified that her lab and the analysis she did here is not sequencing analysis, it's something different. Whether or not she could do sequencing analysis is irrelevant to the analysis that she did do. If Mr. Burt wants to call an expert to say sequencing analysis is better or something like that, that's fine. But this expert does not do sequencing analysis. Therefore, the line of questioning that goes into sequencing analysis is irrelevant to her testimony.
Let me see if I could lay a further foundation.
All right, so I'm going to sustain the objection. And the question may be asked if council chooses.
When you do your analysis using length only, do you go by the rule that if any STR locus fails to match when comparing the genotypes between two or more samples, then the comparison of profiles between the question and reference sample is usually declared a non-match, regardless of how many other loci match?
No, it's not quite that simple. What you're speaking of is an exclusion, is that correct?
Yeah, right.
So it's possible for DNA evidence to, we spoke about, it's possible that DNA evidence be degraded. In a case like that, there may be the potential that some of the profile has what we call dropped out. So it's not present. In that case, we wouldn't expect necessarily to have a inclusion or exclusion at that location because there's no information present there. So it's not quite as simple as is every allele in this chart present in the evidence. There's more to it than that.
If you had a difference in sequence between a known and a question across many loci, would you exclude the person?
It depends.
Again, objection, Your Honor. We're going back into sequencing, which is not the analysis that was done in this case.
Mr. Burt.
Again, Your Honor, if there could be an exclusion based on this and the testing was not done, I think that is relevant.
But as it relates to this witness and her firsthand knowledge, I'm not seeing that tie-in as it relates to her.
All right, let me move on then.
So I'll sustain the objection.
Now, you said that all the samples you looked at in that one report were mixtures, correct?
Correct.
And the number you get in the likelihood ratio depends on how many contributors you estimate, right? The number is going to vary if you say I think it's a mixture of 2 people versus I think it's a mixture of 5 people.
It's not necessarily the number of contributors. The likelihood ratio speaks to the weight of the evidence. And so it's comparing known individuals to the unknown sample. It could be a low number and be a single source sample. It could be a high number and be a 4-person mixture. It's not necessarily directly correlated with the number of contributors.
Let me ask you if you agree with this. This is from the NIST mixture study. An likelihood ratio numeric value is not a measurement of a physical quantity. Do you agree with that?
Correct.
Rather, it is a ratio of probabilities in the opinion of the expert assessing the likelihood ratio and is dependent on the specific propositions used to formulate it and also on the individual making the assessment.
Correct. Yes, I agree.
And does the final likelihood ratio depend on the number of contributors you assume?
No, it does not.
It has no effect whatsoever.
It can have an effect. It's possible. It's possible multiple other factors could contribute to the likelihood ratio.
Is it somehow difficult to figure out how many contributors there are in a sample?
I guess I would say that I use my my training, education, and experience in order to determine the number of contributors present in a profile.
Well, I noticed throughout your report, you used the phrase, for instance, with regard to the 1.2 sample, the profile consistent with at least five contributors, at least one of which is male. And for 1.1, you say the profile is consistent with at least 4 contributors. I assume by the word at least, you're signaling that it could be more.
Correct.
And as the number of people to a mixture increases, the difficulty in sorting out that mixture increases as well, correct?
Correct.
I noticed in your standard operating procedure, there's some guidance on interpreting 3-person mixtures. Familiar with that, right?
Yes.
And it says, and correct me if I'm wrong, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures based solely on number of alleles present.
It's possible for them to present. Yes.
Well, it doesn't say it's possible. It says, for example, approximately in all cases, assuming a mixture as a result of the combination of 3 people must be done with caution. For example, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures based solely on number of alleles present.
You said you're referencing my SOP.
Yes,
Is it possible for me to take a look at it?
sure.
Your Honor, I'm going to object at this point. The point that defense counsel is getting at is made in the last answer, which is that the difficulty of sorting out mixtures increases as the number of contributors increases. That's all understood, but that has nothing to do with probable cause determination. Even if it's difficult, the inferences and the evidence is weighed in the favor of the state. The court cannot weigh the difficulty in determining this evidence. Is it fair for a trier of fact at a jury? Sure it is. But we're now getting into weight issues that are relevant for a jury, but not for this court.
Well, he's implying this is going to be an extended discussion. I have one question which he wants to look at her manual to make sure it's in there. So, and then I'm done.
All right, I'll allow this question, so I'll
Thank you.
overrule the objection. She may review the material and
So could you bring up
question can be rephrased.
one exhibit, Oliver 148? This is your SOP document, correct?
Correct.
And then go to page 83. Did I read that correctly?
Yes.
And so it's true, is it not, that approximately 70% of 4-person mixtures present as 2 or 3-person mixtures?
It's possible.
Thank you. That's all I have.
Thank you. We've been going for a bit, and depending on how much cross, I'm trying to decide if a break is warranted or if Mr. McBride, you wish your cross is limited. Again, not trying to say which way you should go. I'm just trying to weigh whether we should take a break.
I will probably be, I'll probably be 20 minutes.
All right, let's just keep going, and then at that point, we can take a break. Thank you, Mr. McBride.
Good morning.
Morning.
Is your lab accredited?
Yes, it is.
What does that mean?
So our laboratory goes through a voluntary accreditation process where a external third party comes in and audits our laboratory to a set of standards. Specifically, the ATF laboratory is accredited, and specifically the DNA section of the ATF laboratory is accredited to 2 sets of standards. One is an international set of standards called ISO 17025 for testing laboratories. And additionally, a DNA specific set of standards put forth by the FBI.
Does the accreditation require that the methodologies you use be validated?
Yes,
The methodologies used in this case have been accepted by courts across the country, correct?
correct.
Does the accreditation require that forensic biologists like yourself satisfy certain qualification standards?
Yes, we're required to perform competency testing prior to participating in casework. And additionally, we participate in twice a year proficiency testing.
And do you satisfy the competency and qualification standards required by accreditation?
Yes,
And at the time you did the testing in this case, did you satisfy those standards?
yes.
Moving to your opinions, where on the firearm did you find evidentiary support for the inclusion of Tyler Robinson?
There were several locations. I'd have to refer to my report.
Okay, would you look at your report? And this is, it looks like report number, or exhibit number 30. If we can pull that up just for the witness. Thank you, Kimberly. We had it for a minute here. Let it go. Okay, if we could go to page number 2, please. Will you just list off the areas of that firearm where there was support for evidentiary support for inclusion of Tyler Robinson?
The swabs of the stock and grips of rifle, the swabs of the butt plate of rifle, swabs of the trigger and trigger guard of rifle with possible ridge detail / smudging, the swabs of the bolt of the rifle with possible ridge detail / smudging, and the swabs of the forend of the rifle.
We go to page 3.
Swabs of the barrel of the rifle with possible ridge detail / smudging, the swabs of possible ridge detail / smudging on the optical accessory.
And page 4.
The swabs of the protected underside of the receiver of the rifle after disassembly. The swabs of one 30-06 cartridge case. The swabs of one 30-06 cartridge. And the swabs of one 30-06 cartridge.
I want to ask you about a couple of those conclusions. Let's look at page 5, please. And calculation number 3, exhibit 1.3, do you know where that swab was taken from?
I'd have to refer back to page 2.
Can we refer back to page 2, please, Kimberly? Thank you.
1.3 is the swabs of the trigger and trigger guard of the rifle.
All right, going back to page 5. And we've had some talk, some testimony from you and some questions for you about the likelihood ratios. What was your conclusion as to the likelihood ratio that you analyzed in this question in calculation number 3?
For this exhibit, the DNA profile was at least 1 trillion times more likely if it originated from Tyler Robinson as the major component and 3 unknown unrelated individuals than if it originated from 4 unrelated individuals.
You say at least 1 trillion times more likely. So it could be a much higher number than 1 trillion. Is that accurate?
It's possible.
But the protocols in your laboratory say you cap that at the number 1 trillion. Is that right?
Correct. We would not report a number higher than 1 trillion.
And it looks like you also did a probability statistic as well in paragraph E. Is that right?
Correct. It's another way of stating the likelihood ratio statistic.
And will you state your findings you made here in paragraph E, and that's on page 6.
The probability of an unrelated individual in the population who has not contributed DNA to the sample yielding this level of support is less than 1 in a trillion.
And same question there. The trillion number, it could be far less than that, but you stop your calculations or the statistics at 1 trillion. Is that right?
Correct.
Let us move to page 7 with regard to statistical analysis calculation number 7. Now, do you remember what 1.3 or 1.13 and 2.1 are?
I'd have to refer back to page 3, I believe.
You could jump to page 3. Thank you, Kimberly.
Page 4, I'm sorry.
Page 4.
The 1.13 is the swabs of the protected underside of the receiver of the rifle after disassembly. And 2.1 is the swabs of 1 30-06 cartridge case.
Now, did you do the swabs themselves?
I did not.
And 2.1 is a cartridge case, is that right?
Correct.
And what's the difference between a cartridge case and a cartridge?
The cartridge is unfired, cartridge case has been fired.
Right. Let's jump back to page 7. And what was your conclusion with regard to, well, first of all, why do you group these two together, exhibits 1.13 and 2.1 in your conclusions here?
They were both mixtures of 2 individuals, and they both yielded a likelihood ratio of the same magnitude, so they can be grouped together.
Okay. It's not that they were tested together?
Correct.
It's just that the results were of the same magnitude, so they were reported together. Is that right?
Correct.
All right. What was your conclusion as it relates to both of these as to the likelihood ratio?
The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson as the major contributor and an unknown unrelated individual than if they originated from 2 unknown unrelated individuals.
And did you make a conclusion here as well about the a probability statistic?
Yes, so the probability of an unrelated individual in the population who has not contributed DNA to these samples yielding this level of support, so meaning yielding this likelihood ratio, is less than 1 in a trillion.
Nothing else.
Mr. Burt.
The 1.3 sample is described as swabs of trigger and trigger guard, right?
Correct.
You didn't do the swabs, but am I correct that you have no way of knowing which part was from the trigger and which part was from the trigger guard?
Correct. So they were swabbed together, so I wouldn't be able to say where the DNA came from.
And that's one of the samples that was degraded, correct?
There were signs of degradation present in that sample, yes.
And you said with regard to that sample, that that was a sample consistent with at least 4 contributors, right?
Correct.
And did what you term the major profile have the largest amount of degradation in that sample?
There was, yes.
And you can't tell us anything about when the DNA was deposited on the trigger guard or the trigger, correct?
Correct.
You can't tell us anything about whether, when you say it's at least 4, it could be 5, 6, or 7 people with DNA on that trigger or trigger guard, correct?
Correct, which is why we have the major contributor that is suitable for comparison, and the minor contributor is not suitable for comparison due to that complexity.
And again, major, minor just has to do with the levels of DNA you were seeing. It has nothing to do with someone being engaged in activity that is major in relation to the minor contributor.
Yes, so the major contributor is the majority of the DNA contributed to that sample.
Okay. And some of these samples, you have major contributors of more than one person, right?
Correct.
So for sample 1.1, swabs of stock, you have 2 major profiles, and there are at least 4 contributors on that sample, right?
Can I refer to my report?
Sure. It's Exhibit 30. Plaintiff's 30. Right?
You said Exhibit 1.1?
Yes.
Yes, it was a mixture of 4 individuals. There were 2 major contributors.
Okay. And again, with regard to all these samples, no way of knowing when or how the DNA got on those samples, correct?
Correct.
You referenced another statistic in your report, which is the statistic related to paragraph E, I guess.
Correct.
Is it what's called the random match probability statistic? Or is that something else?
It itself is not a random match probability statistic. It is a way to represent the likelihood ratio similar to a random match probability.
But it's still a likelihood ratio computation, right?
Correct. It's based off the likelihood ratio computation.
And it's still subject to all the limitations we've talked about.
Correct.
Can't attribute it to any person. Can't state it's infallible. Can't state there's a 0 error rate. And you can't state that it is a source connected with any one person, correct?
Right. So part of not being able to state source attribution is the reason we report the likelihood ratio statistic. It speaks to the weight of the evidence. And so yes, we can't do a source attribution, and we report that statistic and address that uncertainty that way.
And address the uncertainty along with the other limitations we talked about.
Correct.
Thank you. That's all I have.
Thank you. Anything further for this witness?
No.
All right. May this witness be excused? All right. Thank you, ma'am. May I step down? Anything further from the defense?
No, we have no further witnesses.
All right. Returning to prosecution, anything further?
No, Judge, we have no rebuttal evidence to present at this hearing. The state has no rebuttal evidence to present at this hearing. However, before we break, there is the matter that was discussed yesterday with respect to publishing in the courtroom Exhibit 12.1 so that the victim's family can observe that.
Thank you. All right. Do the parties wish to be heard as it relates to this briefly, and then the court will issue its ruling?
Your Honor, I actually just want to make a quick record. We have advised Mr. Robinson of his right to testify at this hearing, and he is choosing to take our advice and not testify.
Is that correct, Mr. Robinson? And I note that he's nodding in the affirmative. Thank you, Ms. Visser. All right. In regards to the outstanding issue about the publication of State's Exhibit 12.1 to the courtroom only, to persons here, any further input from any of the parties before the court issues its ruling?
Jeff and I, on behalf of the victim, my understanding is you ruled yesterday that you were going to play it, that you did grant our request. So I don't know if we.
Thank you.
Judge, I might simply add, given the court's ruling this morning with respect to displaying exhibits, we may want to make a record with the live streaming folks here that it's not going to be published.
Thank you. All right, nothing further from any of the parties? Okay. Just updating some notes. All right. The court wishes to readdress yesterday's ruling in light of this morning's sanction as it relates to Exhibit 16. The court separately addressed that incident and imposed a sanction on the record. Having considered all applicable public access, fair trial, privacy, and victims' rights interests, the court adheres to its prior ruling. The court finds that temporarily limiting live stream to audio only while Exhibit 12.1 is displayed is necessary to prevent the inadvertent publication of the exhibit from being transmitted to outside the courtroom, and no broader and is taking the least restrictive means to accomplish what is being requested. Accordingly, Exhibit 12.1 may be viewed by all persons physically present in the courtroom, including victim representative Ms. Kirk in her capacity as the victim representative. The same in-court viewing rules applies to all parties and courtroom attendees. And that is the ruling of the court. Let's go ahead and proceed to that, to the stage. So could the camera operator let me know when we're switched to an audio only? We are? Okay. All right. And as it's switched to audio only, to the state. Now, my understanding there's no audio on this surveillance on 12.1. Is that correct? All right. All right. So let's go ahead and play that. And I'm going to rule that this also applies to the still photographer. It cannot be captured the screen in any way. I noted video recording, but I intend as well as no still capture of any of the monitors during the publication of 12.1. All right. And to the stage, just let me know if you're ready. Let's go ahead and play it now. that concludes the playing of Stacy Exhibit 12.1 video. Transmission may resume. Just let me know when that is live. All right, thank you. Does either party need the benefit of the record?
The state does not, Judge.
No, Your Honor.
All right. So this preliminary hearing is continued to September 1st at 10 a.m. for an in-person hearing. The court will allocate up to 4 hours total for argument. That's encompassing both parties. Does the defense request that Mr. Robinson be physically present for that hearing?
Yes, Your Honor.
All right, we'll make the recording. Thank you. The court appreciates the professionalism, civility, and respect shown by counsel, the parties, and all persons in attendance throughout these proceedings. As there are no further matters before the court, this proceeding is adjourned until September 1st at 10 a.m. Good afternoon to you all.
All right.
Hold on, I'm listening to this other thing.
And to the stage, just let me know if you're ready. Let's go ahead and play.
Hold on. That's some fucking bullshit.
Yeah, it is.
I didn't even get to catch the end because I was listening to this stupid thing. I
So-
don't know. I can't pay attention.
So the
'Cause I was-
decision, so he's got till September to decide whether this will go on.
Oh Lord, ain't nobody got time for that. Hold on, I'm backing it up.
Well, you know it will go on, but
Ready?
Yeah.
Sorry,
it's okay.
I didn't get to hear it. Oh God dang. Oh shit.
Stacy Exhibit 12.1 video transmission may resume. Just let me know when
It
that
already did.
is
Okay.
live.
Camera dude already did it.
All right, thank you. Does either party need the benefit of the record?
Really?
The state does not, Judge.
No, Your Honor.
Whoa.
All right. So this preliminary hearing is continued to September 1st at 10 a.m. for an in-person hearing. The court will allocate up to 4 hours total for argument. That's encompassing both parties. Does the defense request that Mr. Robinson be physically present for that hearing?
Yes, Your Honor.
All right, we'll make the
Wow.
recording. Thank you. The court appreciates the professionalism, civility, and respect shown by counsel, the parties, and all persons in attendance throughout these proceedings. As there are no further matters before the court, this proceeding is adjourned until September 1st at 10 a.m. Good afternoon to you all.
What? That's some weird shit. What's the freaking point? Oh my God. That is wild. Well, I feel like I wasted time. Do you? Jeez. I don't get it. Whatever. I said, whatever, bitches, and the bitches, whatevered. Well, anyways, this is what we got going on later. Let me scoot up closer to my mic. Sorry. Oh. Right here. I scheduled it. Yay, I did it. So I'm gonna share this link out. Oh, no. I always do weird button stuff. Copy. And yes. Oh my God, go away. I always like my videos. It counts. Just that one time. Can't hype them though. Anyway, so this is for later. 8 o'clock Central Time. So whatever that is, it's 9 o'clock Eastern, it's 7 o'clock Mountain, and 6 o'clock Pacific. Did y'all see Anjanette Levy was the guest for Trisha? I was like, wasn't she at CrimeCon? Wasn't she the one that was in the bar talking to Lori Hellas when all that shit went down with Christina? Yeah. Mm-mm-mm. I don't like it. Where you at? Oh, that's outside. Okay. I want to heard a burst of sound. I was trying to listen for that slip up too. It'd be right. I was listening.
Folks here that it's
Screen
not going to
recording.
be published.
Thank you. All right.
Oops. Ollie's
Nothing
wrong with me.
further from any of the parties?
Oh my God.
Okay. Just, okay. Just,
I think I might have been wrong.
notes.
It's like he's typing it into Chat GPT.
The court wishes to readdress yesterday's ruling in light of this morning's sanction as it relates to Exhibit 16. The court separately addressed that incident and imposed a sanction on the record. Having considered all applicable public access, fair trial, privacy, and victims' rights interests, the court adheres to its prior ruling. The court finds that temporarily limiting live stream to audio only while Exhibit 12.1 is displayed is necessary to prevent the inadvertent publication of the exhibit from being transmitted to outside the courtroom, and no broader and is taking the least restrictive means to accomplish what is being requested. Accordingly, Exhibit 12.1 may be viewed by all persons physically present in the courtroom, including victim representative Ms. Kirk in her capacity as the victim representative. The same in-court viewing rules applies to all parties and courtroom attendees. And that is the ruling of the court. Let's go ahead and proceed to that, to the state. So could the camera operator let me know when we're switched to an audio only?
I think I was wrong.
Okay. All right.
He was
And
lying.
As it's switched to audio only to the state. Now, am I understanding there's no audio on this surveillance on 12.1?
Right there. He said surveil. Okay, so I'm not tripping. I'm just trying to understand what the evidence is. I don't know if they said what the evidence was, but I don't know. I just kind of caught that. And I'm really just excited because I'm not tripping. So he went to say, I'm going to watch this, whatever, surveillance.
All right.
Hold on.
And as it's
When he
switched to
stopped.
audio only to the state. Now, am I understanding there's no audio on this surveillance on 12.1? Is that correct?
On the surveil on 12.1. Anyways.
I understand there's no audio on this surveillance on 12.1. Is that correct? All right. All right. So let's go ahead and.
Okay. All right. Not tripping. Not today. Not today, Satan. I wish it would show the small screen. Like side by side. Like if it were me and Donna up here. Like if it were like that. It won't. I want to fix them. Damn it. Anyways, all right, whatever. Yeah, I don't know why you couldn't hype it. That's freaking pissed. That shit right there. You couldn't hype my last video about Trasha. That kind of pisses me off a great deal. Oh, yeah. Okay, I'm sorry. I'm just reminding myself right now. Let me go type it in. There is a name that is associated with Lauren's dad, Schwanky. And I got to spell it right, damn it. It's a weird name. And I've heard it before somewhere else. And so I'm going to look at my Google Photos and see if anything pops up. Keyword search. Come on, where's it at? Wait, what's his name? Paul Schwanky. Schwanky. I've seen it somewhere else. I've heard it somewhere else. And I want to know. So let me paste it in here and let me just look. Let me take Paul out. Paul. Oh, no results. Whatever. Anyways. All right. I've been digging. Digging a lot. Because, I mean, for Randall Lake to be one of Jameis Johnson Sr.'s friends on Facebook, I find that really interesting. I'll just say interesting for now. Ooh. Speaking of interesting. That's kind of scary. I know her dad has eye problems, but I don't remember this picture. Do y'all? That is kind of reminds me of her glasses. They just need to be red. Let's see. Oh yeah, and this is Lauren and her brother. And oh yeah, I'm still doing research into her book. I don't know. I want to clarify something. This is her brother dressed up. Tech nerd. Let's see. I got these from Jameis Jr.'s account. Twin Towers, symbolism. I don't know what these pictures are. It was kind of different. Little. I find it concerning, but whatever. That's just me. Black and white. Oh my gosh. The U.S. is just so dang great, Adrian Johnson said. Jameis Johnson. I don't know who that is. Maybe a girlfriend. I don't know. Come home, Daddy. This Eli Hall said. Okay. Just landed, baby, maybe? What the fuck? Let's go back. I don't know who Eli is. Hacker. There you go. Okay. Ella? That's not Eli. I did not see Lauren, as a friend. That's kind of weird. Columbia Law School. Anyways, that's what I have for now. He's the founding member of and chief pleasing officer of Pleaser, whatever, Deo. This is why I thought maybe that guy changed his name, that lawyer dude. Because isn't it like Dowell or something like that? Weird. I thought maybe he did it, because it needed to be changed, because he needed to, maybe in order to fly under the radar. I don't know, allegedly. Or it could have been in memory. I really don't know. But a collective of crypto luminaries. Luminaries, interesting word. DeFi leaders and NFT collectors. He is also founding partner at Perceptive Capital, a cryptocurrency-focused investment firm that serves as a native digital asset hedge fund. Previously, he was senior machine learning engineer at, Wavelet Health, where he had deep learning-based exercise classification of wearable sensor data. What the fuck? Where he had deep learning-based exercise classification of wearable sensor data using LSTM, recurrent neural networks. Sounds like Nerd City. Sounds like some fucking MK Ultra shit. I'm just saying. That's how foreign it sounds. That's why I want to familiarize myself with it, so it's not crazy and out there and just dubious, you know. Where he built an article recommendation engine and algorithm inspection tool based on Doc2 VC, whatever. Anyways, fuck. I don't like all that shit. Yeah, I just find the best way is like to learn something and not be curious or suspicious of it is to know what it is. He was a full stack software engineer at Paperspace, where he deployed scalable metrics, monitoring, and visualization for all of the distributed services. Jameis was a software engineer for HireVue, where he conjured up backed APIs and UIs for the company. Well, hopefully it wasn't a UTI, right? Blockchain investment, Filecoin maker, I don't know. Ethereum initial coin offering. Why is this so fucking foreign? Cloud inspection of both. He sounds like maybe his sperm was, valuable. I don't really fucking know. What the frog? Anyways, what the frog? Is it? Oh my God, that's where you need to join me on that, because I'm like, what is all this stuff? I'm trying. It's just a lot to learn. It really is. This is Jameis Johnson. Well, not now. It's What the Frog. But this is Jameis Johnson. This is Lauren's brother that passed away, that I've been, just kind of poking more into, because we don't know that much on him.
I'm thinking that girl that we saw him with might be their little sister, because they adopted a child. No, she wasn't Chinese.
No.
Okay, well,
no.
Put your glasses
Ella,
on, Donna.
Ella is Oriental or Asian looking, yeah, or whatever, yeah.
But that was not her in the picture.
No.
Okay, sorry.
Nope. Oh no, don't be sorry. It's how we learn. It's just, I don't know. I get Mason vibes here with the black and white. Is that alcoholic? He also has a tattoo on the back, his like right arm, back elbow, I think.
They look like styled up missionaries.
Right. Yeah. Yeah, that's a good point.
I saw several of those at the coming in the front of the courthouse and sitting in front of the courthouse, people who were dressed like that, and I figured they were missionaries or something.
Dang.
There's a lot of security. There's like security hanging out in front of that building. Then there's the actual sheriff's department. And then every time a big car rolls up, a couple of those big guys that were just hanging out there go out and meet people. There's probably as much security in that courtroom as there is, other people.
Yeah. I'm listening. I'm sorry. I was just thinking, I see Lauren right here, but it's weird. This is her dad's Facebook. Because some of those people that were looking in Christina's TikTok, remember that video we went over where it showed how many times people looked in from Lauren's side of the whatever. I just find it interesting, and some of those people are listed in a RICO lawsuit filed against pretty much a lot of people in the family.
Early on, Beach Bum made a suggestion, and I don't know whether it ever got to you or not, but it was a good one. And it was to have a panel and have Christina and Janice and that little group of those girls, that little bunch there.
That does sound like a good idea. I don't know if they'll, I'll try. That's all I can do. All they can do is tell me no.
And we can tell our audience to lay off talking about LDS while them girls are up here.
Yeah. Yeah. Now, Christina did pay me a compliment, you know. I mean, she does, I think she does great for having to, you know what I mean, to be split or to hear it, the cognitive dissonance that's going on.
Yes.
But she was like, she paid me a compliment about how, you know, I say the Church of Jesus Christ of Latter-day Saints. I don't always say Mormon. Anyway, so that does make a difference, I guess.
I guess it does. Maybe I'll have to work
I
on
definitely
that.
don't want to, like, I never want to piss anybody off. I never want to offend anybody. But
Well, the thing
I do
about
have
it
to
is,
my line,
if
you know.
if they were Baptist people, we'd be running down Baptist. If they were Catholics that
I
had
mean, we
been
gotta know
murdered and
better.
murdered somebody, we don't mean
gotta
all
know better.
Catholics. We don't mean all LDS. We don't mean all Scientologists, for God's sakes. I'm sure there are many sincere people in these organizations that do not know what's going on around them.
Yeah, for sure. And I mean, she knows a lot. We need people inside the organization, I've come to learn, to
Jason,
just be aware and to be on the inside fighting, right? At least be aware. That's the big part, is no consent. It's like no informed consent. So it's
Right.
like, you know, we need people on the inside too, is how I look. This is Randall. This is that Randall Lake art. Randall Lake Springville Museum. So Randall Lake was named in a TVPRA, not TPUSA, but TVPRA, which is the victim. I forget the acronym things, but it's a federal lawsuit. The Hamblin daughters filed against their mom, their dad, David Levitt, Randall Lake, this guy right here, this person right here, and Gordon Bowen. And I think that's it. Or they said does 1 through 100, but you know, they're listed as does, so we don't know who it is. But so whenever I was looking through Jamis's, her dad's Facebook, I found where he's friends with Randall Lake art, and I'm like, okay, I might not be in the right place right now.
Okay. Well, now that is interesting.
I mean, just to know, or just kind of maybe fill in some context as to why. I mean, what are the odds that Lauren's dad is also, or that the family could potentially also be connected, not connected, but I mean, in the same circle, you know, the same people, Randall Lake, I mean, and Tom Harrison, and come on now. And she went, you know, was in the same ward as what's her name? Dick and Brenda Miles. And I mean, come on now.
Well, no wonder that that Chad Daybell's sister-in-law, Heather, doesn't want to talk to anybody or be interviewed or fool with any of those people. Now that when you just think about it,
yeah,
she's trying to wake herself up and be her own person, and she's not sure who she can trust, which it seems to, I would have thought she could have trusted Lauren or John DeLynn, but now I'm not so sure. Now, I don't mean anything against John DeLynn. Maybe she could trust. I don't know. This has made me question all of them.
Mark
because
Epstein, whatever the fuck that is.
They are too trusting of one another. They're not Mormons anymore, but they still think for some reason that they're more honest than other people, and surely this one would not lie. It's just crazy as hell. But I mean, I do the same thing. If somebody told me that a Jehovah's Witness was doing something bad, my first thought would, well, I bet they weren't a very good Jehovah's Witness, or I wonder if they were going to the meeting. Are we making excuses? You know what I'm saying? Instead of saying, you know, evil can be anywhere, and it sure can.
Oh, I'm listening. I'm listening, but I was reading.
We'll have to have some, like, maybe a once a week during the daytime update between now and September, or once a month at least, to
Right.
on
Yeah.
this Charlie Kirk situation, and if there's any new things going on with it. I'm
Yes.
telling you, I my first thought when I heard, blowing up microphones and things like that, I thought, now that's crazy as hell. But then at the same time, as soon as it happened, everybody said, well, he must have had on a bulletproof vest or some kind of thing, because his shirt came up so weird and did that
Things
thing,
weren't adding up. Right.
And so, and two, that looked like if it was a gunshot, he would have been shot from the back. You know what I'm saying? Because
Yeah.
all that, it would have went in the back and came out from the front that way.
Something.
And yeah, that it just didn't look right. I don't know anything about it, but it didn't look right. I was not watching it live when it happened. I was watching something else live, and somebody said in the chat that Charlie Kirk had been shot, and I switched over to try and find it. And for about at least the first half day, that video was playing everywhere.
Really? I didn't know.
And then they scrubbed it, and you get took down in a minute.
Oh, really?
For putting that thing up. Yes.
I mean, I would hope blur it out, but damn, that's crazy. Oh, y'all got to hear it. Y'all got to listen to this. Y'all got to. Okay. It says, I set up my uncle's Tesla to fart when he uses the turn signal.
So we're gonna go right. Take that off.
Oh my God.
You know what?
You know what?
You're a sick man. You're really sick. No, you really need help. No, I'm gonna see as soon as I get home if I can get somebody to help you. No, because you seriously, you need it bad. No, you need it. For you to listen to that, you need it. See, this looks like we're going the wrong way, right? But see, now you can reverse that. Oh, and go like that. You are really disgusting.
Yeah,
you're a disgusting man. Could you imagine if I was on a date and you did that and I didn't? Why would I be with you going on a date? I said you did it and I was on a date. Yeah, and I didn't know it. And I was on a date and I made a turn and did that. How far do you think I would get with that lady? Well,
Boys do stuff like that, don't they? I remember my kids had a whoopee cushion or something that they would put under a cushion. You would make a poop sound. You know what I'm talking
Oh,
about?
yeah.
And then they learned to do it on their arm and this and that, and it was like a whole thing.
Boys.
I had 3 boys going around there acting crazy. I told my son, I told him he acted like Jim Carrey in Ace Ventura. He was just so dramatic about everything he did.
I had a Mustang that I hung out the window like Ace Ventura.
Oh.
We were on our road. I was on my road with my best friends. We went to go get a comforter from my house, because I was spending the night at her house. Needed more blankets, so I went and I sat on the blanket, and we're just being stupid. I mean, that's when that movie was out hot and heavy,
Yeah.
We were teenagers.
I probably didn't see it till it was on that
Still love this.
You could rent it or something. I don't remember.
Freaky.
Now
I've never seen the movie, so
I'm gonna dream about that. I saw my mother's walker, and that she has 2 walkers. One that's like a hot rod, it's got big wheels on it to go outside.
Wow, yeah.
And so last night when I was coming down the hall, I saw those wheels, and I imagined in my head a tricycle that looked about like that right there. Now
I'm looking for. I did a video. I shared it here even, but I don't see it. The finished one, And I thought it would be a lot simpler than this. And of course, I know better. Here we go. Here's this one.
Yesterday, obviously, the Vice President of the United States had the privilege of hosting Charlie's show on Monday. And then the Daily Wire crew, Matt Walsh, Michael Moles, and I hosted Charlie's show on Tuesday. Glenn hosted Charlie's show yesterday. And he did something that I thought was pretty amazing. He brought along the EIB microphone, the Excellence in Broadcasting microphone that Rush Limbaugh used during his days. And he gave it to TPUSA. He put it on the desk in front of Charlie's chair, paying tribute to Charlie. Here was Glenn yesterday.
I brought something with me today that I thought was appropriate while I did the show, that I would sit in front of Charlie's microphone. It was given to me after the death of Rush Limbaugh by his wife. It is Rush's golden microphone.
Mm. Yeah.
Good heavens.
Yeah, right. Fake cry. Fake cry. You don't get an Emmy. That's for sure.
I think it's appropriate that it sits in front of Charlie's microphone.
Glenn Beggs, you know that y'all wasn't going to the same heaven anyway. You had them 3 levels, and what's his face wasn't going to the same heaven as you.
Right?
Yeah. What you crying about?
Here's this
Maybe
thing again. I found it finally.
Oh,
Go ahead.
he's probably already went down there and baptized Charlie Kirk for the dead. I bet you
Oh, for
anything
sure.
that he's been baptized about 2,500 times by different people. I want to
mean,
baptize Charlie Kirk for the dead. Oh, that's sweet of y'all. Y'all want him to get in that 3rd level of heaven with you.
Oh, yeah. That's a celestial champagne room. All right. I'm going to play this real quick. Well, I'll say real quick, but this is what I'm going to share later. I shared a little bit of it already. I made this part of it. Hey, JoJo. Oh, no.
Today, we're going to pick up blockchain-based tokenized socks. As of today, these socks cost $22,000. This is a whole aura.
What? Redeem, you cowards.
Should I get rid of these? It recently passed $1 trillion in all-time volume. I'm not interested in technology for its own sake, but really for how it can be used to have some sort of impact. It's been just really cool to see what other people have done with it. I find it where it intersects with technology and culture becomes a lot more interesting.
It is extremely custom.
Yeah, it's very custom.
Water cooled.
Yeah.
To make sure.
Yeah. The conception of Unisocks, it didn't touch your real world life yet. What are the other use cases of this technology? It was an experiment like, how do we use Uniswap to sell physical goods? The most simple to understand form of Unisocks is they are a physical pair of socks. Initially, Unisocks were released as a token on Ethereum, and they were put into a Uniswap liquidity pool. Since the more people buy them, the more expensive they get. The more people sell them, the cheaper they get. There's something down there I want to show you.
Bonding curves.
Uniswap is built on a specific type of bonding curve called a constant product market maker. For each additional sock that was purchased from the liquidity pool of socks, the next sock would become more expensive programmatically along a curve.
Sounds like bullshit.
Ultimately, the last sock could never be sold because its price would be infinity.
It pulls you down the rabbit hole. If you can understand how the price of Unisocks works, well, wow, now you understand how all Uniswap liquidity pools work.
To receive the physical pair of socks mailed to your door, you have to burn the ERC20 token, which is the cryptocurrency. At the same time as we sent you a physical pair, we issued a NFT of the socks, which functioned as a digital receipt, proof that you redeemed it.
And we weren't even going to issue an NFT. I was actually resistant. And now that's a legendary, iconic piece of Unisox. You know, it just started getting really fun and interesting and like something I could explain to my mom.
All three forms of sock have separate values and marketplaces.
No.
Another interesting thing about Unisocks is it became a social token for DeFi OGs.
Crypto itself was like memed into existence. Memes are funny and cool. Governance is boring. Unisocks appeal to everybody.
People who love Uniswap and participated in early did create a lot of value for the Uniswap ecosystem.
It also had to come at the right time. It had to come at a moment when people wanted something to explain.
They keep your feet warm. They can make you money. They
They're
can
fuzzy.
let you into a Telegram chat.
The fact that Uniswap had chosen to recognize
Right? The more you know. So I need Andy to get on her machine. Okay. And I need her to do some digging into those names, those company names, that production company, Pleaser, whatever the hell. I don't even remember. That's how quick my mind. Pleaser House. Yeah, because I feel like this whole side of everything is off limits because we don't understand it. And those that do, I mean, I don't see anybody talking about it. So you got some swampland for sale? Awesome. Yeah. Yeah, the tree stuff. Yes, I'm going to throw that in tonight too. And I also have this video that hold on, that I'm going to share. I mean, it's the podcast people talking, the
final chapters were just violently torn out like 50 years ago.
Oh,
Okay.
Wow. Yeah.
Right. And for decades, those stories just stopped on a cliffhanger. There was no resolution, no ending, just this permanent question mark.
And historically, I mean, the criminal justice system just kind of accepted that. We categorize those lost endings as, permanent mysteries, box them up in evidence rooms, and just let time bury them.
Exactly.
Yes,
But now,
Shane
and
Baldwin,
this is
yes.
what we're getting into today. A new technology is actively rewriting those missing pages. Like ink is literally appearing on the paper right before our eyes, finishing stories that have been sitting on shelves for decades.
It's honestly incredible to watch it happen in real time.
It really is. So welcome to the deep dive. We are jumping into a massive, totally fascinating stack of sources today. Specifically, we're looking at the extensive RSS feed and case logs from a true crime show called DNA ID.
Which is such a rich source of information.
Oh, it's brilliant. And our mission for you, the listener, is to explore how investigative genetic genealogy, or IgG, is fundamentally rewriting the history of cold cases.
It really is a complete structural shift in how we approach forgotten history.
Yeah. So, I mean, it's 19 minutes, but we'll watch this later and stuff like that. But for sure, the total tree call, I mean, it's concerning as far as, like this. Tell me more about Project 525's fundraising tactics. Now, Trisha fundraises exactly for this. It'll be in her description box, and it's under Othram. And Carolina Hurtado is who kind of drilled this in for me. The fundraising tactic for Project 525 rely heavily on what researchers call a monetization mirage, a system that uses the emotional weight of unsolved juvenile cases, child cases, to mask a highly structured corporate cash flow. The primary fundraising engine for this initiative operates through the true crime forum Web Sleuth and its owner, I need to change that to manager, Trisha Griffith, who acts as the public relations arm for Othram Labs. Following Othram's strategic investment in Web Sleuth in late 2023, Griffith turned on monetization features like Super Chats on her YouTube live streams, claiming that every dime raised goes directly to Othram's DNA Solves platform to fund $7,500 DNA tests. However, forensic audits of this setup reveal several significant financial transparency issues. YouTube automatically takes a 30% cut of all Super Chat donations. When creators claim every dime of a donation goes to solving a case, they are using the net figure to obscure the gross reality, meaning a large chunk of the community's money never reaches the laboratory. unless the creator is replacing that 30% deficit out of pocket. Then the nonprofit, reality. To the public, these streams are framed as charitable giving. In reality, DNA Solves is not a 501c3 charity. It is a proprietary crowdfunding platform owned by Author Labs, a private for-profit biotechnology company. Routing YouTube revenue to them is technically a business-to-business transfer, not a tax-deductible charitable donation. The AdSense trap and the 60-day tail. Google AdSense does not allow creators to magically redirect funds directly to a charity at the point of origin when the payments are taken in. The payments must go to the legal business name on the account, such as WebSleuth LLC or Author Labs, making the funds subject to taxes. Furthermore, standard AdSense pays on a 30-day cycle. Researchers noted a 60-day delay in these payouts, which strongly indicates the presence of a multi-channel network, like an umbrella, MCN, or a corporate middleman, like Authrum, holding, verifying, and managing the funds before dispersal. Corporate quotas. Observers who watched Griffith track live donations noted behavior suggesting she may have a quota or contractual obligation to generate a certain amount of revenue for Authrum. This raises serious ethical questions about whether she received separate compensation to act as a corporate spokesperson disguised as a grassroots advocate. Bing bong. Ultimately, these tactics effectively turn the platform's large audience of citizen detectives, or web sleuths, into an unpaid labor force and captive donor base. By using the undeniable tragedy of 525 dead children as emotional bait, the network encourages the public to crowdfund investigations, thereby generating capital for the very corporate tools that Authrum sells. Anywho, so there's that. Oh, I thought I was showing it, but it wasn't nothing special. Anyways, okay, I know. I'm just keeping y'all here. I need to go, get ready for the next one. Yes, that's what I was thinking. I'm like, oh my God, they're okay. So because you say it's, oh my God, I've got so many questions. See, just because you say it's worth something and you can't see it, it's like that cloud space thing. I'm like, why am I paying for cloud storage? Why am I always running out of storage on my devices? Why? How? Tell me how it takes up any fucking space. Okay. It's ridiculous. So that's what it reminds me of. But yes, when Joseph Smith printed his own money, I don't remember if it was Nauvoo or if it was I don't remember. I don't remember where it was, but yeah, he did. That and printing presses. He also was not for the First Amendment, if you ask me, in my opinion. That's just me. But and then I made this little short, and it's not the real. I made it from the photo, so, but it's got Jameis on there opening that fucking. It was so expensive. It was like, I don't even remember, $5 million, or I don't remember exactly. Don't quote me, but something to do with the Wu-Tang Clan. And I'm just like, what? This is a big deal, and I want to understand it. I want to understand what is happening over here. He was going to invest in hidden true crime. It says hacker on one of his things on LinkedIn. I'm like, okay, hacker, you're a hacker.
Celebrating the life.
Oh,
we found it. Thanks for coming, everyone. Welcome to Hidden True Crime.
Welcome to Hidden True Crime. Crime. Anyways, yeah, back to Anjanette Levy. She works for Law and Crime. What the fuck is she doing going and interviewing with freaking Trisha, of all people? Ew. Trisha, you nasty. You still nasty, ho. Anyways, all right, I got it out of my system. All right. You need to do something? All right. I know, me too. All right, guys. Justice for Tylee, Charles, Tammy, JJ, and Joe. Always. And Charlie. Love always wins. You guys are proof. I'll see you tonight at 8 p.m. Central Time. Be there, be square. Bye.
Cause you're under pressure, under pressure. Pressure. You're cooked. Pressure. Like your shitty ass book. The pressure is real. The pressure is real. The pressure is real. Pressure. You're under the pressure. Drowning in the pressure. You're now under pressure. Pressure. Pressure's got you by the tongue and it's over now. You're under pressure. The pressure.